It be pleases your lordship. On behalf of your lordship, you Sharma, your lordship, I have taken consent of the other side, your lordship. This matter is part. So your lordship, since
Which matter?
Item number 6, pertaining to item number 6, I have taken consent, your lordship, is not well.
Ms. P. does learned counsel
Kindly please this.
appearing on behalf of Mr.
You Sharma,
Q.
secretary.
Sharma, learned standing counsel for the Secondary Education Department with consent from the other side as for listing the matter after
Date may be fixed, my
A
lord.
week, your lordship.
After a week.
The week, my lord.
after a week.
For
There is
August
accordingly allowed recess and list the matter on
6th August. Obliged, my lord. Obliged.
In your lordship, pertaining to item number 21, also your lordship, although I made communication with him, your lordship, but his voice is breaking, your lordship. I could not be able to hear his side voice, your lordship. The same, your lordship, joint prayer is there, your lordship, since all the records has submitted by him, your lordship. So your lordship, item 21 and list this matter again after a week, your lordship. Any date may be given, your lordship, convenient to you, your lordship. This matter is also, your lordship, appeared by you Sharma, and in this matter, your lordship records is also submitted.
No. Did you obtain consent from the other side?
Your lordship, I have, your lordship, I made communication, your lordship.
No,
right?
we'll call the matter.
Yes, your lordship. I'm deeply obliged.
If I may, my lord, I beg to mention item 19, my lord. On the ground,
19.
yes, my lord. On the ground that, my lord, there are two analogous appeals, my lord. Only 106 has been listed today. There is another second appeal, which is numbered as RSA number 107/2025. My lord, both of the matters may be heard together, my lord, as they arise from the same judgment, my lord. There was a counter claim.
This RSA 106 has already been tagged with another RSA, being RSA number 105.
Yes, my lord. My lord,
Okay. In RSA 106, another RSA is tagged with.
yes,
What
my
is the
lord.
number?
107, my lord.
107.
Yes, my lord.
Mr.
G. Imtiaz, my lord.
Learned counsel for the appellant submits that another RSA, being RSA number 107 of
5, my lord. 2025.
2025 is pending before this court, and both the matters are required to be heard together and press for listing both the matter together after
My lord, any date, my lord.
on
Deeply
8th of August. There is accordingly allowed for recess and list the matter along with RSA number 107 of 2025 on that day.
Deeply obliged, my lord.
Right, please, lordship. Lordship, I beg to mention item number 32 on behalf of Mr. S. Samaria, lordship. I'm for the caveat report. Lordship, in this matter, lordship, the motion part is already over, lordship. It's wrong.
Item number
32, lordship.
32.
It's wrongly come under order column, lordship.
In which column it ought to have come?
Admission, lordship.
Admission.
My lord, I am for the petitioner here.
Yes.
Actually, this matter was heard in part by Justice Devashish Barua, my lord. I have the copy of the order, my lord. So,
Okay.
Lordship. Last paragraph.
16:6 order.
Last paragraph. my lord.
And last paragraph में kindly be, my lord. On which date the matter would be further heard.
Heard Mr. Jay Sharma, learned counsel for the petitioner, and Mr.
MM Zaman, lordship.
M.M. Zaman, learned counsel appearing on behalf of Mr. S. Samoria, learned counsel for the respondent. Mr. Sharma pointed out that this matter is heard before another court in advance of this court. Accordingly, it is provided that list the matter before the appropriate bench
For admission.
for admission.
In the next week, my lord, it may be listed in next week. It may be listed in next week, my lord.
So you go to the list.
May I please, Lordship? Lordship, With the consent of other side, I beg to mention item number 23 of daily list, Lordship.
Item number?
Sorry, Lordship, item number 29, Lordship. Due to Lordship sudden personal inconvenience of my senior, Your Honor.
Okay. Mr. Upadhyay, any objection? After 3 weeks.
Lordship, there is interim order that may be.
Okay, Mr. Your good name?
M. Boro, Lordship.
M. Boro, Learned Counsel, appearing Learned Counsel with consent from the counsel for the petitioner with consent from the other side as for listing the matter after 3 weeks.
Lordship.
After 3 weeks. Parallel.
My lord, I wish to mention RSA, my lord, two RSA, which were left over, my lord, several times, some urgencies there. May I pray for listing on any convenient date my lord, in the next week, my lord, on hearing day, my lord?
Take a date from
My
me.
lord.
May I please, Your Lordship? I would like to mention item number 15.
Item
15, 1 5. Kindly adjourn the matter for the date senior is not available today, Lordship.
1-5.
1 5.
As read for by Miss
As Fugan.
as spoken, Learned Counsel for the accused. Raises a list the matter after 1 week.
Yes.
After
Yes. I beg to mention two MSA appeals, my lord, under the orders column, my lord.
when?
My lord, there are two MSA appeals, my lord.
When?
My lord, any date convenient to this one?
Take a date from him.
May I please, Your Lord? First, I pray for listing a IA civil, Your Lordship, connected with MEC appeal.
When?
Any date for orders? 1st August. Stop, Lordship.
RSN 99, my lord, you lordship by order dated 20 of June, my lord, directed to amend quash title.
Hmm.
We amended and filed on 24 June. And
Yes.
it is not listing. I approached the registry, my lord. They are, my lord, saying that unless you mention.
When
So-
do you want?
My lord, day after tomorrow, my lord, Friday.
Right. Okay.
Lordship, I pray for listing of 3 MEC appeals, 1 for hearing and 2 for orders, Lordship. Lordship, next week, any day, Lordship.
Take a date from him.
Published, Lordship.
You have a CRT also.
When?
Any date next week.
When?
Any date next week.
Yes.
May it please, Your Lordship, I beg to mention for listing, Lordship,
Hmm.
1 MSc appeal, Lordship, any date.
Any date this year or the next year?
Next week, any date.
Next week.
For listing.
Take a date from him.
May I please, my lord.
Hmm.
My lord, in the connected appeal, there are 5 appellants, my lord. Out of that 5 appellants, 4 this file this IA, my lord, to abandon their appeal, my lord.
Fine for the appellant number 5, Lordship.
Heard, Mr.
K.M. Hassan.
Learned Counsel for the applicant. And also heard Mr. U.B. Sharma, Learned Counsel for the respondent. Mr. K.M. Hassan submits that the applicant, namely Rumi Begum, is not willing to proceed with the matter and press for according her permission to abandon.
My lord, Rumi Begum and another 3 also there, my lord.
All the 5 applicants.
4, my lord, 4 applicants.
Lordship, I am the appellant number 5 and I want to proceed with the appeal, Lordship, but they are not, the other 4 appellants are not willing to proceed with the appeal. Lordship, at page number 3, Lordship. Page number 2, Lordship.
Rumi Begum, Arifa Ahmed, Arifullah, Arfatullah. These four appellants are not willing to proceed with the appeal. I am the appellant number 5, Mohammed.
Okay, all right. You follow line. Applicant, Srimati Rumi Begum, oh no, Mrs. Rumi Begum, Mrs. Arifa Ullah Ahmed, Mrs. Afia Ullah, and Mohammed Efrod Ullah are not willing to pursue the appeal, being RSN number 184 of 2022. And as such, Mr. Hassan submits that the aforementioned applicant may be permitted to abandon themselves from the instant appeal. Mr. Sharma, learned counsel for the respondent, submits that he has no objection.
I am not responding. Appeal number 5, Lord.
On learned counsel for the appellant number 5 submits that he has no objection. Taking note of the submission of learned counsel for both the parties, this application stands allowed, permitting the 4 applicants to abandon themselves from the RSA number 184 of 2022. In view of above, Mr. Sharma shall file amended cost title within a period of 1 week from today.
Items for motion items 1.
Lordship, matter may be taken up after some time, Your Lordship.
Item 2.
Lordship, can it be fixed on some other day?
Why?
No, Lordship, we have some urgency, Your Lordship. They have already taken time earlier also. My senior will, Miss R. Chaudhary, she will do the matter today. So after some time, Your Lordship.
At 2? Can it be at 2?
Okay.
Deeply obliged.
Item 2.
May I please, Your Lordship? I have filed the additional affidavit by annexing the copy of plan, but 2 pages are missing. Kindly may I allow to add the 2 pages in the affidavit.
As read for by Mr.
Ardaka.
Ardeka, learned counsel for the petitioner, SSL is the matter. Okay. 6 of us.
Items 3 and 4.
Lordship, I'm on behalf of B. Fukon, learned counsel for the item number 3. He has entered his appearance by filing wakaf number yesterday in the next item, that is RSA. And there is a IA in the RSA for a delay of
19 days,
19 days, Lordship.
19 days.
As per the learned advocate B. Fukon, he will file objection in this IA regarding the delay. So it's just some time may be granted, he's out of station.
Okay. As read for by Mr.
N.M. Hazarika.
Learned counsel appearing on behalf of Mr. B. Fukun, learned connecting counsel for the petitioner. Having not been objected by Mr.
My lord, we don't have any objection, but the question is, my lord, they have filed on
Your
the
name.
case Singha, my lord.
Yes, in the learned counsel for the, you are for the respondent.
No, my lord, I am the appellant in the RSA, my lord, item number 4.
For the appellant in RSA number.
RSA, my lord, is not numbered, my lord, because there is a delay.
Okay.
We have filed the delay, my lord.
Connected RSA.
Item-
SSL is the matter after a week.
My lord, only my prayer is, my lord, already they have proceeded with the execution, my lord. So that should not be, my lord,
Let him appear in the next day.
because they filed, my lord, that's why I'm saying. Otherwise, only 19 days delay, my lord.
When it was filed, execution. process.
Already, my lord,
I'm not
it's
able-
pending, my lord.
After 1 week, let us fix it at the
First August.
first of all.
Bless you.
My lord.
Item number 44.
Merits. And this prayer of the petitioner, my lord, to transfer the title should is found in here, my lord. As because there is not lies here, it is as per the my lord, Article 28 of the my lord, their constitution, that is called my lord, Manipuri Sahitya Parishad, Constitution of Manipuri Sahitya. I have annexed the same, my lord. And also, my lord, on the ground of the petitioner here in your lordship is
No, where the suit is pending.
short is pending in the hearing Guwahati, my lord. Pending, my lord, title should not 322/24. Pending in the civil court, my lord, civil justice court, my lord, Union Division number 1, Kamrup Metro, Guwahati. And next date given, my lord, on 13/7/24 necessary order. Only, my lord, in this case, we have filed the reinstatement, and in the reinstatement, we have only stated that the case is not maintainable here, my lord. As because Article 28 of the my lord, Manipuri Sahitya Parishad, my lord, there is a constitution on that, my lord. And that your lordship may kindly see annexer, my lord,
So, no, here, what is your prayer?
my prayer, my lord. Only to transfer the case from here to the Kasar Silchar, my lord.
Why?
As per my lord, the cause of action, my lord, here, my lord, is not lies and Silchar because they are their constitution, my lord. There is a constitution, written constitution of the Manipuri Sahitya Parishad, my lord. And moreover, my lord, the petitioner, your lordship,
Please go at this SS.
my lord.
Let notice go.
Now, my lord, the next date is 30th, my lord. So, my lord, before
No,
that,
that's right, but we are not going to state
no, yes, kindly similar only my prayer, your lordship, annexer, my lord, your lordship, I am giving, my lord. That, my lord, your lordship may kindly see annexer 3, my lord. Your book is there, my lord, their constitution. I have also annexed the same, my lord. Please, that is why, my lord.
Let the other side appear. We will issue notice. Thereafter, we will consider.
No, next date is 30th. So, my lord,
Maybe you file an application there that one transfer petition is pending for this month.
and then, my
But
lord,
Mr. A. Rosit, learned counsel for
and the
petitioner.
petitioner, my lord, is physically handicapped, my
In
lord.
this petition under section 24 of the Code of Civil Procedure, it is section 151. The petitioner has read for transferring of title suit number 322 of 2024 pending before the Court of Learned Civil Judge Junior Division number 1, Kamrup Bank, Guwahati, to the Court of Learned Civil Judge, Kasar Silchar. Where is the petition and the documents placed on record? Let notice be issued to the respondents, returnable in 4 weeks. The be taken by reserve post with AD and also by usual process within a week. Okay. Release the matter after 4 weeks. The interim period of the petitioner will be considered on appearance of the other side.
Item 45.
Wait, please, your lord. My lord, in this case, lordship was allowed to file additional affidavit, my lord, regarding the order by which family court was pleased to call the marriage officer, my lord. I have submitted by way of additional affidavit, my lord. And lordship will find in page number 59, 60, and 61, there is the order. In the first order, consider the application and thereafter hearing of the sides, my lord, was pleased to call the marriage registrar officer. 59 is the order, my lord, page 59, last part, 28/6/2024. That petition was considered, and thereafter, my lord, after hearing, page 61, my lord, 7/9/2024, marriage register was summoned.
So then,
Lordship.
you have been asked to produce that order of the trial court by which summoning of the marriage officer was allowed.
Yes, that order is, my lord, will find page my lord 61. Seven nine 2024. Issue notice to the marriage officer, Kamrup Metro, respondent would take steps. Thereafter, reissue my lord it. That order is, my lord, already I have annexed here
So,
also.
regarding registration of the marriage,
Yes,
is there any dispute?
my lord, they have disputed, my lord. They are saying that
Oh.
we obtained, my lord, respondent.
I am the petitioner in the family court.
Family.
So
So they are,
You have disputed the marriage.
yes, my lord, because
Disputed the marriage.
yes,
because of that age.
No, no. According to you, marriage was not solemnized.
Yes, ma'am.
Acha.
and which is obtained by fraudulent means. Their claim is that.
So you have disputed the marriage.
Yes, ma'am. So we have filed a petition for nullifying that marriage, ma'am. Before that family court, ma'am. I am the petitioner in the family.
So what is your submission?
My lord, regarding this revision, my lord, we have no objection if the petition is allowed. If marriage officer can be called for, my lord, and only a time period may be framed by this honorable court that within a period of 30 days or 45 days, that procedure has to be completed according along with the cross exam.
Okay.
We have no objection in allowing this petition.
Heard Mr. Ziuddin, learned counsel for the petitioner, and Mr.
A.N. Sharma, my lord.
A.N. Sharma, learned counsel for the respondent.
Respondent.
This petition under Article 227 of the Constitution of India related Section 150. 151 of the Code of Civil Procedure, the petitioner has challenged the correctness or otherwise of the order dated 3/4/2025 passed by the learned principal judge family court number 1, Amrup M. Edward. Within bracket trial court hearing after in FC civil case number 534 of 2018. It is to be noted here that by the impugned order dated 3/4/2025, the learned trial court has held that calling of the marriage officer Ahmed M. at Guwahati to ascertain the age of the petitioner will serve no purpose. Mr. Ziuddin, learned counsel for the petitioner, submits that the learned trial court at first, by order dated 7/4/2024, has allowed the petition number 393 of 2023 filed on 27/3/2023 for calling the marriage officer to prove the marriage certificate. But subsequently, by the impugned order dated 3/4/2025, the learned trial court held that calling the marriage officer to ascertain the age of the petitioner will serve no purpose. And that unless the marriage officer, Mr. Uddin further submits that since the marriage is disputed by the respondent opposite party, the respondent herein, there is a requirement of examination of the marriage officer to prove the marriage between the petitioner and the respondent. And under such circumstances, the impugn order dated 3/4/2025 is arbitrary and illegal, and therefore Mr. Uddin contended to set it aside and to issue direction to the learned trial court to call for the marriage officer to examine the marriage officer. Examine the marriage officer. Mr. Sharma, learned counsel for the respondent, submits that he has no objection in the event of allowing the civil revision petition, provided a timeline is fixed for examination of the said marriage officer before the learned trial court. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents placed on record, and also perused the impugn order dated 3/4/2025. 3/4/2025. And also the order dated 9/7/2024. It is to be noted here that the petitioner herein that filed on petition being petition number 393 of 2023 on 27/3/2023 for calling the marriage officer Kamrup M, along with register to prove the marriage certificate. And by order dated 7/9/2024, the learned trial court has allowed the said petition. But subsequently, by order dated 3/4/2025, the learned trial court has held that calling the marriage officer to ascertain the age of the petitioner will serve no purpose. But since the marriage has been disputed by the respondent herein, this court is of the view that there is a requirement for summoning the marriage officer to prove the marriage certificate between the petitioner and the respondent. It is also to be noted here that fair trial is right of both the parties, and in fair trial, fair opportunity has to be afforded to both the parties to establish their case. In the instant case, denial of the denial. No, in the instant case, instant case, recalling the order dated 7/9/2024 while impugn order dated 3/4/2025 amounts to denial of fair opportunity to the petitioner to prove his case, prove her case. And in that view of the matter, the impugn order dated 3/4/2025 appears to be illegal and arbitrary, and on such count, the same instance set aside and passed. Consequently, the learned trial court is directed to summon the marriage officer along with the marriage registered.
Marriage officer, man.
Marriage registered.
Registered.
Marriage registered. Marriage registered. And thereafter, to proceed with the case in accordance with in terms of the CRPI stands disposal. Have you filed your wakalat now?
Yesterday only I filed.
Yes, sir.
Yes, my lord. May I pray for a time period, my lord? Within a time period that procedure has to be completed. In a period of
and the said exercise has to be carried out within a period of 30 days.
My lord.
But are you sure that you have filed your wakalat?
Yes, my lord. Yesterday only we filed.
It has not been shown in the system.
There might be some defect with the filing section.
You go and correct
Yes.
it right now.
Right now.
Silence for admission. Item number 5, partner matter.
Regarding abandonment of a teacher, and earlier Milord also I approached the old code and old code in the past order Milord. Kindly see that order Milord. Page 43. And relevant portion Milord, page 46. Paragraph 8 Milord.
Yes.
Married Milord. Paragraph 8 Milord. It goes without saying that since there is already a finding by the authorities that the select list dated 27/10/1919 is a valid, and if the name of the petitioner is found to be included in the said select list as claimed by the petitioner on the strength of the documents laid upon in this petition, or any other document as may be available, the petitioner would be entitled to be declared as a valid appointed teacher, and she shall be also entitled to all the consequential benefits, including arrear and current salary, for which the respondent authorities will undertake a fair verification process as directed above, and inform the result of the same to the petitioner by issuing a speaking order in this regard, which exercise shall be undertaken within a period of 2 weeks, 2 months from the date of receipt of the certificate copy. And then, my lord, I obtained a copy and submitted the same before the authority. Then, my lord, I was, my lord, appointed as a tutor, and I am getting a fixed salary of rupees 10,000 per month. That is, my lord, your lordship may kindly see page 52. This is typed to me. Forest copy is there also, my lord.
Page number
52, and that's a 15.
52. Yes.
Made. Office of the Director of the Elementary Education, Milan, so in excess of the power conferred under upon Director of Elementary Education Assam by government letter number so and in presence of government letter approval number communicated by data and number EDNLC so dated 27/1/21 and subject to satisfactory police verification report and production of physical fitness certificate from concerned Joint Director of Health Services. The following candidates is hereby accommodated as a tutor in LP school. I was given an LP school, one purely temporary basis in a fixed salary of rupees on 10,800 per month. So now I am getting the same, my lord. And my submission before lordship is this. Advertisement was made on 20th/11/1999. I have given the same, my lord, annexer 1, page 850.
So now you have been appointed as tutor.
Tutor.
You are drawing salary at a rate of rupees 10,800 per month.
My lord.
Per month. And this order was passed on 30th January 2021.
21.
So your pair is for appointing you as teacher.
Regular.
Teacher.
Teacher.
Regular teacher.
My lord. Yes, because, my lord, I am coming on simple, my lord. Advertisement was made 1999. I applied for the same. I was selected and I was appointed there. Then, my lord, in the same school, my lord, with valid appointment letter. Then, my lord, my name also, my lord, forwarded to the treasury officer for payment of salary.
For
payment of salary. Kindly see, my lord, I have annexed the same, my lord. Kindly see, my lord, annexer 7, page, my lord, 31.
annexer
7.
page number
Page number, my lord, 31.
serial number
My serial number, kindly see, my lord, second page, page 32, my lord. From below, my lord, fourth, my lord, from below fourth. Lovely Das. Page 32, from below, my lord, serial number, my lord, here is given fourth, my lord. Lovely Das, my lord, female, general candidate, my lord, HSC pass, my lord, and so on. So now of the school where I am working, my lord, number 394, Nilboni LP school, so on, so my lord, and salary given, my lord, so on, so my lord, but pay is held up. And that is why, my lord, I was not getting my salary, my lord. And till the same is going on, my lord, kindly see last page, my lord, I am seeing, my lord, page 38, my lord.
is
Page 38 of the
38.
same, my lord.
Yes.
Page 38, my lord. So the same, my lord, similar, my lord. From below, my lord. from below, my lord, serial, my lord, line number
Pay held
10.
up.
10.
Why?
Herein also, my lord, pay held up. Some other person there, my name is there, right side there is a paid held up.
Hmm.
But why they are not paying, that the reason is not given to us, my lord. And as because, my lord, I was regularly selected, I have
Yeah,
given my
okay,
select list.
okay. Mr. Sharma, what is the case?
Lordship, here, what happened, Lordship, we have filed our affidavit.
Hmm.
In reality, the petitioner is illegally and irregularly appointed teacher, Lordship, initially. And subsequently being a irregular and illegal teachers, in terms of the cabinet.
That cabinet memorandum.
2020, Lordship.
Yes.
He has been subjected to the appearing before the screening committee. And he was, in terms of the cabinet decision, Lordship, he was accommodated as tutor with prospective effect. And he duly accepted and he joined and he's drawing salary without disputing.
He or
That-
she?
She. Lovely das. So she accordingly accepted the terms and conditions because that accommodation in terms of the cabinet decision was taken that they were initially illegally and irregularly appointed teachers. So government took a decision that as a one-time measure, subject to verification, and there are certain criteria. Those who receive salary up to a particular period of time, those who have basic training, they have been accommodated, and accordingly the petitioner has been accommodated with prospective effect. The said terms and conditions the petitioner has accepted and duly joined by furnishing the undertaking also. Because there is a condition to join, they have to furnish an undertaking. Now, Lordship, may kindly see the select list which my learned friend is claiming to be actual select list, that is not the select list, which he is claiming to be the select list according to which he has been selected. Lordship, may kindly come to our affidavit, Lordship. Page number 56.
Page number?
56. Affidavit filed by the director, elementary education. In fact, the page starts from 55. Relevant paragraph starts from page number 56. Paragraph number 5, Lordship. That the deponent states that as reported by the district elementary education officer, Karimganj, by letter dated 1/6/2023, the advertisement was issued, but the petitioner was not selected. As per the Honorable Court's order dated 15/12/2013, passed in WPC number so and so, the case of the petitioner was placed before the expert committee for consideration of her claim for payment of salary. Thereafter, the government verified the records and after verification issued an order dated 18/7/2013 stating that the name of the petitioner did not appear in the proper select list dated 27/10/1999, which select list, the proper select list which we have brought on record by way of an additional affidavit, Lordship.
And you show me the proper select list?
Lordship.
This select
list we have brought it by way of an affidavit. Lordship, may for a moment kindly peruse this Honorable Court's order dated 7/4/2025, on which day that original select list was produced. Your Lordship has perused, and the Lordship directed me to file an affidavit by bringing on record that select list. So this select list we have filed by additional affidavit dated 14th of May 2025. Your Lordship will find at page number 68. This is the select list, Lordship. Select page number 69, Lordship.
In this select list, there is here, her name is absent.
Her name is not there, Lordship, because petitioner is claiming that her name appears in serial number 35 according to my learned friend. But there is, her name does not appear in the select list of candidates for the LP school teachers selected by the sub-divisional level selection committee, selection board, Karimganj, in its meeting dated this 27/10/1999. Her name is not there in that actual select list. Her name is not there.
What's that?
No, one. And Lordship,
Yes.
Lordship, may I again, once again read that paragraph number 5, page number 56, that earlier affidavit filed by the director, Lordship. Thereafter, the government verified the records and after verification issued an order dated 18/7/2013, Lordship, paragraph number 5. I'm reading from the middle. Stating that the name of the petitioner did not appear in the proper select list dated 27/10/1999, which was approved by the Divisional Level Advisory Board, Karimganj. The select list which has been obtained by the petitioner is not valid select list. The petitioner submitted review petition dated 13/8/2013, which was rejected by the government by the order dated 26/9/2013. Next paragraph, Lordship. That the DO Karimganj further reported that the petitioner obtained a select list from one Shamal Datta, who is not the official authority. In paragraph 19 of the writ petition, the petitioner also states that she obtained the select list dated 27/10/1999 for 111 numbers of candidates through RTI from Sri Shamal Datta. It is to be mentioned that the directorate has issued a direction to the Deputy Director of School, Karimganj, to file an FIR and criminal case on the charge of fraud and forgery against the Shamal Datta. The petitioner in WPC number 2010-3 of 2010, by letter dated 17/6/2016. Next paragraph, Lordship. That the name of the petitioner figured in the list, the name of the petitioner figures in the list dated 13/11/99, which has no valid original documents. So the appointment of the petitioner was found illegal, as the petitioner's name is not entitled in the valid select list as per the government order dated 18/7/2013. The petitioner is not entitled to arrear salary as claimed. The Honorable Court, by order dated 12/3/2020, passed in WPC number 509 of 2013, directed the authority to re-examine the claim of the petitioner in the light of the select list produced by the petitioner and to make another verification as to whether the name of the petitioner finds place in the select list dated 27/10/1999. The Honorable Court further directed that if the name of the petitioner is found to be included in the said select list, the petitioner would be entitled to be declared as validly appointed teacher, and she shall be entitled to all the consequential benefits, including arrear and current salary. However, on verification, it is found that the name of the petitioner did not figure in the valid select list dated 27/10/1999, and therefore the petitioner is not entitled to pay any benefit. The speaking order is required to be passed. Now, paragraph number 8, Lordship. That the deponent states that the petitioner was categorized as illegal, irregular teacher, and after a screening process, she was newly accommodated as tutor by the order dated 30/1/2021, issued by the director. So in the said order, it is mentioned that the accommodated tutor will get prospective effect from 1/11/2020, and he or she cannot claim any benefit whatsoever in respect of the past service rendered by him or her prior to 1/11/2020. The petitioner has accepted the order of accommodation. Now, Lordship, may I take your Lordship to that order? Page number 54 of the writ petition.
Page number?
Page number 54, Lordship. The last page of the writ petition.
Last page of the?
Writ petition, Lordship, writ petition. That accommodation order, the appointment order.
Next are 15.
Right. Okay, type to complete typation. Now, 54, Lordship. That after that there is a format, Lordship, district Karimganj, name Lovely Das, name of the school, so and so. Now next, the post against which the appointee is accommodated as tutor is purely personal in nature and will cease to exist as and when the incumbent retired from service. Because this is one-time measure was taken by the government. The appointment is issued with concurrence of the finance so and so department, which is communicated by that so and so. Next, the accommodated tutor will get the prospective effect. This is a terms and condition. The accommodated tutor will get prospective effect from 1/11/2020. As a lordship. Only, and he or she cannot claim any benefit whatsoever in respect of past service rendered by him or her prior to 1/11/2020. So these terms and conditions has been duly accepted, and she has accepted her order of accommodation, city on and drawing salary lordship. Therefore, the select list which the petitioner claims to be her name to be appearing there is not the proper select list. The proper select list are visual lordship, where her name is missing. Therefore, she is not entitled for any arrears salary lordship. And according to this order, she has been drawing salary and she has been accommodated. And she being her appointment being illegal and irregular, she was subjected to appearing before the screening committee. We see appeared before the screening committee. Had she any issue on her earlier appointment, she would have not participated in that screening process also. She had participated, she accepted the appointment order with prospective effect. Now, lordship, she is claiming for her arrears salary, which she is not entitled to.
My submission was that as per advertisement, I applied, I was selected regularly, I was appointed. That is like page 19, Lordship may kindly see. First appointment will not. 17 is the Milord, original copy Milord and person Milord. Page Milord, yes. Page 15 is the type to be, it will be better for it. First order Milord, appointment order. That was made in Milord 20th/11/1999. Made in Milord. One selection by the subdivisional level selection board for elementary education Karimganj. Srimati Lovely Das, daughter of Sonso Milord, address is given, is temporarily appointed as secondary teacher and posted at 499 Duhalia Primary School on the following terms and conditions. This is my first appointment, and on the basis of same Milord, I was Milord. I joined there, and my name was forwarded to the higher authorities for my salary, but that was not given. And subsequently, I filed a petition, and that directed the authorities to consider my case. Accordingly, I was appointed. Now the question, Milord, I am selected, and kindly see, Milord, how I am selected. My learned friend is saying I am not selected, and I am saying I am selected. As per Milord, my petition, Milord, annexure 5, Milord, page 24.
Page
24, Milord.
Yes.
Serial number 35. My name is regularly appointed Srimati Lovely Das. And this is a type copy. Next page, Milord, I have given Milord the photostat copy of the Milord select list. That is Milord page 26. Same Milord, only I have given type copy there. Page 26, serial number 35. You are unreserved 1538 Srimati Lovely Das, Nam and so school Milo Hoya. Then Milord, inquiry was made regarding Shamal Dutto, who supplied me the RTA copy. And then after inquiry, Milord, that Shamal Dutto was discharged, Milord. There is nothing against him. But I am not on that, that is not my duty. And here is again, page 54, my line of 55, my line of saying the appointment letter to me, Milord. There is no binding that I cannot file any other further proceeding. I have not signed on that point. I am not entitled to get any claim or made any file in the case. And moreover, Milord, my learned friend Milord is saying that the original certificate copies, Milord, original copies of the select list. There is, I have to check, Milord, but I could not find any select list in original. Your lordship, that is not with the lordship also. Probably.
No, it was produced on 9/4/2025.
Can you see,
Lordship was directed me to file in, bring on record by way of affidavit. Lordship may kindly peruse, I'm not, Lordship may kindly peruse the order dated 9/4/2025 of the Honorable Court.
now then you kindly produce now.
9/4, I can produce otherwise.
Yes,
And Lordship,
that is also very, very important.
Lordship,
As per Miller, Evidence Act, Miller, primary evidence is required when there is a question, Miller, it should be produced in original. Let him produce, Miller, I'll see
Okay.
how I.
And one more thing, may I point out, Lordship, Lordship may kindly peruse the prayer. Here, his prayer is for.
And moreover, Milan, I have filed an RTI application, Milan, before the authority, praying Milan to issue a list of teachers who were appointed in illegal process. And the authority, Milan, Karimgaz issued a Milan, the list of teachers who were appointed in illegal teacher, Milan. And they have given list, Milan, about 1,000 teachers, but my name is not there. This is the list, Milan. I can submit your lawsuit also. But there is no my name. So, Milord, that is proof that I am legal teacher, Milord. This is submitted this RTI application, Milord. On by RTI, I received the same on the basis of RTI application.
Anyway, Mr. Sharma, you produce the original.
So original select list I will produce, Lordship.
Original
And
letter.
Lordship, one, that prayer. Here his prayer is for regulation. Lordship may kindly come to page number 12 of the writ petition.
And if required, Milord, I'll file a affidavit, Milord, on the point this a list of illegal teachers, Milord. I'll bring on record, Milord.
As to why a mandamus or circular should not be issued, directing them to regularize the service of the petitioner as LP school teachers and direct them to release monthly and current salary and allowances. So and so. Now he's claiming for regularization. Now this order of accommodation, which I have shown your lordship, page number 54, he has accepted, and this accommodation order has not been challenged. If he was agreed by this order of accommodation with prospective effect, he should have challenged this. He has not challenged it. He has accepted the terms and conditions. He joined and drawing salary, and at the same time, lordship.
There is no bar to file any petition, Milord. And the petition, only I don't know how my landlord is submitting the same, Milord. Petition, Milord, any point I can file.
I heard Mr. A. Rosit, learned counsel for the petition. I also heard Mr. B. N. Sharma, learned standing counsel for the respondents in elementary education department. Heard in part, let's the matter on
19th August.
19 August for further consideration. In the meantime, Mr. Sharma, learned standing counsel for the respondents in elementary education department shall produce the original select list of the year.
Original select list dated 27/10/1999.
27/10/1999. Mr. Rosid, learned counsel for the petitioner, submits that he has also obtained the
list of illegal teachers.
List of teachers appointed in the year 1999.
After 1999
onward by filing one RTI application, and he may be permitted to bring on record the said select list by filing an additional affidavit. There is accordingly allowed. Procedural list the matter on for further hearing.
Item 7. May it please the loss. My lord, this is a regular second appeal, my lord. File in time and within form, my lord.
Second appeal or first appeal?
First appeal, my lord. I'm sorry. It's a regular first appeal, my lord. It is a statutory appeal. It is in time and form, my lord. And we have taken several grounds.
What are the grounds?
My lord, there are several grounds, my lord, I like to highlight before the lawsuits. Ground number 9, my lord. For the plaintiff has no locus to file the suit, as much as the agreement for sale was executed on 9/9/2011 between the Madrasa Ejazwa Gulsane Medina and the defendants, and the suit being filed by Radvia Gulsane Medina Madrasa for Parichalana Samiti and the plaintiff respondent witness, namely PW1, categorically admitted in cross examination there is no document to show that the madrasa Rajua Gulshane Madinai and Rajua Gulshane Madina Madrasa Parichana Samati are one and same. So the plaintiff's name is properly named. Then your lordship also may be pleased to see one vital ground, my lord, page 15, page 6, my lord. For the plaintiff had the knowledge of the breach of performance of the contract as 1 month time was granted for payment of the balance consideration amount and for registration of the sale deed as per agreement dated 19/9/2011. But the plaintiff issued the notice on 27/2/2020 and thereafter the suit was filed on 5/9/2014. That is nearing the period of limitation, my lord, was expiring, not in time, my lord. So as far the, there are some judgments also, my lord. In this respect, I made royal lordship attention to such a judgment, my lord. If you also want to see.
Anyway, let us admit the appeal. We will issue notice to the respondents. We'll call for the record also.
Yes, ma'am.
Heard Mr. Rajbar Bhaiya, learned counsel for the appellant. His appeal is his regular first appeal is directed against the judgment and decree passed by the learned civil judge sitting in Tinsukia entitled suit number 53 of 2014 on 30/4/2025.
I'm also filing IA for stay of
order dated interim judgment and decree dated so and so the learned trial court.
Civil Judge, Senior Division, Tinsukia, ma'am.
Dismiss the counterclaim on contest and decreed the suit of the plaintiff and directed the defendants to execute registered sale deed in respect of the suit land described in plaintiff table of the plaintiff as per agreement between the parties after receiving the balance consideration amount. And in the event of failing to execute the sale deed, then the plaintiff shall get the sale deed executed from court. And also restrain the defendants, their agents, men, etc., from transferring, stroke, selling the suit land described in the schedule of the plaintiff to any other person, to any person. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the interim judgment and decree dated 13th of May 2025. Passed by the learned trial.
My lord, I have also filed an IA, my lord, for they have filed the execution. And I have mentioned the number in my IA petition, page 5, my lord.
So
this may kindly be stated.
returnable and for which step be taken by registered post with AD and also by usual process within a week from today. Rest shall call for the record to the learned tribunal list of the learned trial court list of the 4 weeks. You take down hard Mr. Borbuya, learned counsel for the
Execution case number 7 of 2025, my lord. Page 6 of my IA petition.
interlocutory application under order 41 rule 5 of the Code of Civil Procedure is prepared by the applicant for staying operation of the interim judgment and decree dated 13th of
34/2025, man.
13th of May 2025, passed by the learned civil judge Senior Division, Tinsukia. In
Title suit number.
title suit number 53 of 2014. 14. Mr. Bormuya submits that the applicant has already preferred an appeal against the impugned judgment and decree dated so and so, so and so. And the said appeal has already been admitted by this court and notice has been issued to the respondent and the record has also been called for. And further, Mr. Bormuya submits that the respondent herein, the respondent opposite party herein has filed an execution case being title execution case number 7 of 2025. Now pending before the Court of Learned Civil Justice Senior Division Tinsukia, and since the appeal has already been admitted, there is a requirement for staying the impugned judgment and decree dated so and so, and therefore contented to allow this application. Further, taking note of the submission of learned counsel to the applicant and also considering the facts and circumstances on the record, further proceeding of the operation of the impugned judgment and decree dated 30/4/2025 stands state till returnable date list after 4 weeks.
Much obligement.
Number 8.
May I please also, this is a matrimonial appeal, my lord, against a judgment order dated 8/1/2025, passed by the learned district judge Suhat number. Today is the first day the appeal has come before the honorable court, my lord. It's not yet admitted.
Lord Miss P. Bora, Learned Counsel for the appellant. This appeal under Section 28 of the Hindu Marriage Act 1955, dated Order 41 of the Code of Civil Procedure is directed against such judgment and order dated 8/1/2025, passed by the Learned District Judge Jorhat in title suit matrimonial number 119 of 2022. It is to be noted here that by the impugned judgment and order dated so and so in the Learned District Judge Jorhat dismiss the title suit. Dismiss the matrimonial title suit number 119 of 2022. There is a memo of appeal and the grounds mentioned therein, and also there is the impugned judgment and decree dated judgment and order dated 8/1/2025. Admit issue notice to the respondents returnable in 4 weeks. Respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Rest shall call for the report from the learned trial court. Place the matter after 4 weeks.
Number 9.
My lord, similar is my application, my lord. Here in this case, my lord, the appellant husband has preferred this matrimonial appeal against the dismissal at the London Additional District and Session Judge Morigaon, my lord, by order dated 28/5/2025, my lord. The appellant husband pleaded for divorce on the ground of adultery and, my lord, cruelty. He could establish, but my lord, the London court was not satisfied and eventually dismissed, my lord. The grounds in the applications are from page 10, my lord. Initially, my lord, the husband is working in the army, my lord. Behind the back, my lord, the wife was doing adultery, my lord. And the respondent number 2, with whom the respondent was having illicit relation, was also made a party to the proceedings, my lord. Subsequently, my lord, he was proceeded ex parte in the London court bill also. And PW2 and 3, my lord, who caught red-handed the respondent, my lord, in a compromising position, they were also examined, my lord. There was village meeting also, my lord. And that apart, the London court bill also, my lord, ignored the fact that from last 6 years, my lord, both the husband and wife have been living separately, my lord. So, my lord, at this stage, my lord, what I'm praying is that, my lord, the appeal may be admitted, my lord, and the records may be called for, my lord.
Or Mr. Theory, Learned Counsel for the appellant. This appeal under section 28 of the Hindu Marriage Act 1955 is directed against the judgment and order dated 28/5/2025. Judgment and decree dated 28/5/2025 passed by the learned additional district judge Morigao entitled suit certificate D number 49 of 2019. This to be noted here that by the same judgment and decree dated so the learned additional district judge Morigao has dismissed the suit preferred by the appellant. Oh, young people. For dissolution of the marriage by a decree of divorce. There is the memo of appeal and the grounds mentioned therein, and also there is the interim judgment and decree dated 28/5/2025. Admit issue notice to the respondent returnable in 4 weeks that be taken by registered post with AD and also by usual process within a week from today. This is a call for the record from the learned from the Court of Learned Additional District Judge Morigao. This is the matter after 4 weeks.
Deeply obliged, Your Lords.
Item 10.
May it please your lordship now. My lord, the respondent here is the plaintiff. My lord, he filed a suit for specific performance of a agreement. My lord, the agreement is a page 37. Now, my lord, appellant herein is the
Mr.
defendant.
Sahu, you have filed one caveat.
Yes, my lord. Yes, my lord.
Okay. Caveat would be hard. Caveat next research.
My lord, we are basically against the injunction order, my lord. Injunction order is at page 69. And relevant portion of the injunction order, my lord, dated, it is dated 1/4/2025, my lord, passed by the Civil Judge Senior Division. No, relevant portion is a page
Page number?
74.
Page number?
70, my lord, 70. 1/4/2024, 25. And relevant portion, my lord, 74, my lord. This injunction, how this has been granted, my lord. And 74, last para, my lord. Accordingly, in view of the above, opposite parties are restrained from constructing, alienating or creating any third-party interest over the suitland till disposal of analogous title suit number soins. My lord, here, my lord, there is no prayer in the, my lord, injunction petition for restraining from construction. My lord, this land is required by the, my lord, defendant, is the owner, for construction of a residential house. My lord, my submission is that, my lord, while passing injunction, 3 golden principles to be considered not only from the plaintiff side, but from the side of the defendant also. And at best, the honorable court would have asked for, my lord, undertaking that I will not create third-party right. And moreover, since there is no prayer for restraining construction, that injunction could not have been granted. Well, this is the judgment 2025 1 GLT 384. Here also, honorable court, my lord, honorable court has sought for undertaking to be given before the court below, and accordingly, undertaking given, an injunction was modified, my lord. Because of the fact, my lord, this case will go on, my lord, up to, my lord, not less than 20 years, and I will be the sufferer. So for the contents of the agreement is concerned, we have already disputed that there was some, my lord, financial transaction between the, my lord, parties, and for granting financial assistance at the 50%. This
Mr. Das, let notice go at this.
right,
surface.
right, my lord. Yes.
Third, Mr. PK Das, learned counsel for the appellant, and Mr. Sahu, learned counsel for the respondent. This appeal under section 104 of the Code of Civil Procedure, read Order 43, Rule 1R of the Code of Civil Procedure. Is directed against the order dated 1/4/2025, passed by the learned secretary, senior division reviewer, in exec case number 36 of 2025, arising out of title section number 26 of 2025. Is to be noted here that by the impugn order dated so the learned court below has passed injunction order against the present appellant. Produce the memo of appeal at the grounds mentioned therein, and also produce the impugn order dated 1/4/2025. Admit, issue notice to the respondent. However, no formal notice is required to be issued. How many respondents are there?
Pardon me.
How many respondents are there?
I given the copy.
However, no formal notice is required to be issued since Mr. Sahu entered appearance and received notice. However, extra requisite copy of the petition be furnished to Mr. Sahu during the course of the day. Whether the record will be required, not required.
Not required, already stopped.
Uh,
However, interim order maybe if any, maybe consider on returnable date, madam. I have a prayer for stay also.
Okay. Mr. Das, learned counsel for the petitioner. The appellant submits
Yes.
there is a requirement of staying the impugn order. Dated 1/4/2025 till returnable date. Any objection, Mr. Sahu?
My lord.
In staying the impugn order till returnable date?
No, my lord, that cannot be. I have objection in the stay, my lord.
You have objection.
My lord. Maybe consider on the returnable.
What he has said that a prayer of construction, staying from construction was not there. That is there, my lord.
Okay. However, Mr. Sahu, learned counsel for the respondent, submits that he has objection in staying the impugn order. In order at this stage. Taking note of the submission of learned counsel for both the parties, it is provided that on returnable date, the interim pair of the petitioner will be met.
Oh, bless. Yes.
Item 11.
Hello, I am appearing for the respondent number 1. I am appearing for the respondent number 1. On the last occasion, my lord, petitioner was directed to serve me a copy of the revision petition, my lord. I have not received the copy.
Petitioner, pardon?
My lord, on the last occasion, this honorable court directed the petitioner to serve me a copy of the revision petition, my lord. But
it was not served upon you.
Not served. So,
probably inadvertently, lordship, it has not been served. I'll be serving it today itself, lordship.
Okay.
Can it be taken up, lordship? Some urgency there, lordship, because the next date is fixed probably on 27th, lordship. Huh? Next week, on Monday, lordship, can it be taken up on Monday?
All right. Heard Mr. S.P. Sudhuri, learned counsel for the also heard Mr. A.P. Gupta, learned counsel for the respondent number 1. Mr. Gupta, referring to order dated 38/6/2025, submits that the counsel for the petitioner was directed. The petitioner was directed to furnish a copy of the petition to the respondent number 1, but the same has not yet been furnished. But Mr. Soturi, learned counsel for the petitioner, undertakes to furnish a copy of the same to Mr. Gupta during the course of the day. Accordingly, it is provided that question shall be submitted
Today I'm serving, lordship.
Monday.
Monday, lordship, 28th. Obliged, lordship.
Item 12.
My lord, it is an appeal for enhancement, but I have seen some errors in pagination, lordship. I may be allowed to correct it, or else I'll file an IA for correction under pagination also. The page number 9 goes to page number 11, and page number 11 should have been page number 9 also.
Or Mr. D. Das, learned counsel for the appellant. Mr. Das submits that he may be granted some time to make necessary correction in the memo of appeal.
Lordship.
Memo of appeal. There is accordingly allowed. Necessary is the matter after 1 week.
Lordship. I'll file an application, lordship.
Item 13.
My appeal to lordship.
Is the appeal filed for enhancement of the compensatory amount, Lordship?
Heard, Mr.
P.D. Bhuyan.
Learned Counsel for the appellant. This appeal under section 173 of the MDA is directed against the judgment and award. It 12/11/2024 passed by the learned member MSC number 2 Kamrup M. Guwahati in MSC case number 897 of 2007. Is to be noted here that by reviewing judgment and award dated so the learned tribunal has directed the respondent New India Assurance Company Limited to pay the sum of rupees 2,28,477 rupees, paying the compensation with interest at a rate of 9% per annum.
From the date of filing.
From the date of filing of the claim petition. Where is the memo of appeal and the grounds mentioned there, and also where is the infringing judgment and award dated mentioned. Admit issue notice to the respondent returnable and for weeks. The fee taken by registered post with AD and also by usual process within every number. This is a call for the record on the learned tribunal. Place the matter of 4 weeks.
Much of it.
Item 14.
May please, your lordship. My lord, this is an appeal filed with the insurance company, lordship. It is purely on quantum, lordship. The lordship learned member has wrongly considering the age of the disease, accepted a wrong multiplier, lordship, and further added future prospect to the extent of 10%, which the claimant is not entitled, lordship.
Heard, Miss M. Sodari, learned counsel for the appellant. This appeal under section 173 of the MDA is directed against the judgment dated 23rd/4/2025 passed by the learned member of the accident tribunal, however, in MSC case number 190 of 2023. Is to be noted here that by impugned judgment and award dated so the learned tribunal has directed the appellant herein to pay the sum of rupees 5,87,800 paying the compensation to the respondent hearing.
Claimant. 1, 2, 3, lordship.
1, 2, and 3. 1, 2, and 3. With interest at the rate of 6% or enough from the date of filing of the evidence of the claimant, that is on 29/7/2024 till the date of the evidence. Miss Sodori, learned counsel for the appellant, submits that the appeal is referred on 2 grounds, mainly on 2 grounds. Firstly, Ms. Sodori submits that the learned tribunal has miscalculated the age of the deceased and applied wrong multiplier. And secondly, Ms. Sodori submits that the learned tribunal has directed to pay interest on the future.
No, lordship, wrongly added 10% towards future prospect.
Wrongly added 10% towards future prospect.
Lordship.
Where it is mentioned.
Lordship, paragraph 4 of the grounds. And
No, in the impugned order.
Yes, lordship. In the impugned, lordship will find at page, lordship, 1920, lordship. Page 20. Paragraph 3. Paragraph 3. As the disease was aged within the age, lordship. Page 20, lordship. Of the judgment.
Page
20 of the judgment. Internal page 12.
There are only 17 pages in the judgment.
No, lordship, internal judgment, lordship, the internal page 12, lordship. And serial page number 20, lordship. Issue number 2, Lordship, issue number 2. Next page, issue number 2.
Okay, it is 10% of the future prospect.
Yes.
To the monthly income.
Of the decision.
Monthly income of the deceased on the basis of National Insurance Company Limited versus Furnace Safety and others reported in AIR 2017. 16 SC, page number 680. So what wrong with this?
Yeah, Lordship, wrong is that, Lordship, mainly the age is, Lordship, they have taken 60 years, but it should be 68 years as per other third, Lordship. That was wrongly taken. So wrongly taken, so still 60 years future prospect.
Memo vehicle and the grounds mentioned therein. And also appears the interim judgment and award dated so and so. Admit issue notice to the respondents. Returnable and products that be taken by research force with AD and also by the process within your today. Call for the record from the learned tribunal, list the matter of prior 4 weeks.
There is a stay, Lordship. Subject to deposit of 50%.
50%. Departments and Sotory learned counsel for the applicant. This interlocutory application is prepared by the applicant under Order 41, Rule 5 of the Code of Civil Procedure, or staying in due judgment and award dated 23rd 4/2025, passed by the learned member Motor Accident Claim Tribunal Mawaigaon in MSC case number 190 of 2023. Ms. Sotory submits that the connected appeal has already been admitted and record has already been called for. And as such, there is a requirement for staying the operation of the interim judgment and order dated, award dated so and so. And the applicant is ready to pay 50% of the awarded amount, ready to deposit 50% of the awarded amount before the registry of this court. Where's the application and the documents plus on the record? It appears that connected appeal has already been admitted for hearing. The record has also been called for from the learned tribunal. And the applicant is also willing to deposit 50% of the awarded amount before the registry of this court. And taking note of the submission on Ms. Sotory, learned counsel for the applicant, and also considering the facts and circumstances of the record, this interlocutory application is then allowed. Operation of the interim judgment and award dated so and so stands state till disposal of the connected appeal. Subject, however, to depositing of 50% of the awarded amount before the registry of this court within a period of 3 weeks from today.
Lordship, 4 weeks, 4 weeks, Lordship.
Why?
In the certified copy.
Okay,
must oblige.
Item 46. Adjournment.
Yeah, please, Your Lordship. In this case, Lordship, senior counsel TJ Mohanto is appearing, Lordship. So he's a leg on another court, Lordship. It may come out 2, Lordship.
At 2.
Lordship. Okay.
Item for hearing under Order 41, Rule 2 CPC. Item number 16.
May please, Your Lordship. Lordship, may first about item for timing, Lordship. Senior is in another court.
Timing.
Lordship.
Who will appeal?
MSR Chaudhary. Lordship, may take the matter at 2.
No, 2, we have several other matters. Yeah.
Sure.
Two piece of over.
Item number 17.
May I please, Your Lordship? Your Lordship, my senior is out of station. As such matter may be fixed, adjourned for today.
On?
Maybe fixed that there is an interim stay order for.
Miss, your good name?
Nimpi Brahmo. Nimpi Brahmo on behalf of Manohar Haq Sakya.
Yes, so and so learned counsel appearing on behalf of Mr. M. A. Soikia, learned conducting counsel for the appellant, submits that the learned conducting counsel is out of station and press for listing the matter. After 1 week,
Yes.
here allowed. This is list the matter after 1 week.
Item 18.
Yes, objection.
May I please, your lordship? My lord, here, my lord, the appellant, my lord, principal defendants, my lord, and the learned appellate court modified the judgment of the learned trial court that this impugned order has been passed. And here the only dispute, my lord, that regarding the plaintiff, my lord, before taking to my substantial question, my lord, the prayer of the plaintiff, I'd like to show your lordship first at page 26. Then I will take your substantial question of law. Page 26, my lord. Prayer number 1, my lord, right title interest, my lord, so for schedule 1. Prayer number 2, confirmation of possession, we are not on this, my lord. So for schedule 1 is concerned, there is no dispute where he is admittedly the right, he is having the ownership on, but we are concerned prayer number 2 and C and D, my lord. For conducting survey and measurement to separate to the area of schedule 2 land and to determine the southern and eastern boundary of the schedule 2 under the schedule 1 land and the southern boundary of the schedule 1 land. Number D, recovery of khas possession if any part and parcel of the schedule 2 land are found under the possession of the principal defendants, as well as for granting permanent perpetual in mandatory injunction censure. And number E, my lord. For declaration of amended deed 3006 and 3007 dated 23/9/2011 to be void, illegal and effective, fabricated and liable to be cancelled. My lord, so far as my lord, the trial court answered in favor of the plaintiff the right title interest in question. And rest question, my lord, declared negative. Then plaintiff approached before the appellate court, my lord, and appellate court, my lord, issue number 4, my lord. Can you have a look, my lord? At page 61, issues. Issue number 4, my lord, 4, 5, and 6.
Page number?
Page number 61, appellate court's findings.
Yes.
Issue number 4, my lord, whether the plaintiff is entitled to the relief of survey of southern boundary of schedule 2 under the schedule 1 to separate the area of schedule 2 land, whether the plaintiff is entitled to recovery of khas possession of any part and parcel of the schedule 2 land if any found under the principal defendant, whether the amended deed 3006 and 7 dated 23/9/11 are void, illegal, and ineffective, are liable to be cancelled. Now, my lord, the findings of the appellate court on the so far as survey of the question is concerned at page 66, issue number 1. Point for determination. Page 66, my lord. Sorry, 65, my lord. 65. 1. Whether the learned trial court wrongly decided issue number 4 in respect of survey of the southern boundary of the schedule 2 land without proper appreciation of the evidence adduced by the plaintiff, and as such it is liable to be set aside and reversed. Number 2, my lord. Whether the learned trial court wrongly decided the issue number 5 regarding recovery of khas possession, my lord, without proper appreciation of the materials on record, in that respect, as such it is liable to be set aside and reversed. And lastly, my lord, whether the learned trial court will fail to peruse the documents adduced by the plaintiff and thereby wrongly decided issue number 6 negative censure. Now, my lord, that issue number point 4 discussed very next page, page 66. Whether the learned trial court wrongly decided the issue number 4 in respect of survey of the southern boundary of schedule 2 land without proper appreciation and evidence adduced by the plaintiff, as such it is liable to be set aside and reversed. The finding will lordship will find on this point, my lord, page number 70. The relevant 3 paragraphs, lords will find 9.1, 9.1.17. It is deposed by all the witnesses of the plaintiff appellant that during amicable partition, secondarily got land only in the second arrest pattern number 87. Thus, the inclusion of land under pattern number 241 and doc number 686 by way of amendment in itself shows encroachment of the land purchased by the plaintiff appellant, And as the land of the plaintiff appellant and his vendor is shown to be in the northern boundary of the purchased land of the principal defendants, it is very much necessary that the land be separated through proper survey. Next, my lord. The defendant's respondent admitted that they were not having the land under the doc number 686 or patta number 241 in their original sale deed, and the same was included by way of amendment without changing the boundary. But the inclusion of any new doc clearly extend the land to further north, and thus there is a chance of inclusion of the land of the appellant plaintiff who is shown to be in the northern boundary of question of this. Now, my lord, final paragraph, this 9. Hence, I am of the considered opinion that the plaintiff appellant could successfully show encroachment over his land, and there is necessity of survey of the common boundary of both the parties, and accordingly the present issue ought to have been decided in affirmative. So when the learned appellate court is found, it's a necessity of whether we have, when we made amendment of the sale deed, my lord, we encroached or not, my lord. It is held that survey is necessary. Despite survey is necessary, my lord, order 26 rule 9 has not been exercised, my lord. Whole issue is there, my lord. He's appreciated there is a survey is necessary, but same right has not been exercised, my lord. Accordingly, our deeds has been declared void and cancelled, my lord. So we are before this court, my lord. Now substantial question of frame on this point, my lord. Page 6, my lord. My lord.
Well, resume after 5.
Yes, my lord.
Item number 18 to continue.
My lord, at page 6, my lord, the substantial question of law. One, my lord. Whether the learned appellate court below was correct in presuming that the inclusion of doc number 686 and patta number 241 in the amended dates number so and so dated 23/9/11, the land of the present appellant's principal defendant got increased with the probabilities of encroaching the land of the principal respondent, sole plaintiff, falling under the Schedule 1 land, whereas the appellant's principal defendant has specifically pleaded in the written statement that the land under doc number 686 patta number 241 in the said amended dates was already included in their sale date number 4129 and 4130 dated 11/12/2009. And the amendment was made in respect of putting only the number 686, which was earlier left out inadvertently, since neither the boundary nor the volume of the land has been changed, and the said amendment this. Next, my lord. 2 and 3. Whether the findings of the learned appellate courts below is perverse in respect of the land under doc number 686, patta number 241, the falling under the Schedule 2 land, since the plaintiff has admitted that the vendors of the principal defendant's appellant has inherited lands under the doc number 686 and 687, that they had duly transferred such land in favor of principal defendant appellant. But such facts are completely overlooked by the said learned appellate court. Number 3, I am highlighting this issue, my lord. Whether learned appellate court below was justified in declaring for cancellation of the amended deeds number so and so dated so and so in respect of the land under doc number so and so before completion of the survey to be made by the revenue official in respect of suit Schedule 3 lands. Rest, my lord, the question of law I am not pressing right now, my lord. So admittedly, my lord, both the trial court, the issues framed, my lord, and trial court, so far as this issue service concern, declared negative against the plaintiff, and appellate courts, my lord, declared yes, there is service necessary. There is a disputing so far as in regarding, my lord, boundaries. So in the boundaries, is admitted that there is service necessary. Despite this, my lord, without considering the survey, without exercising the provisions under CPC, my lord, order 26 rule 9, my lord, directly our deed have been.
Now, which substantial question of law you are pressing?
My lord, number 3. Number 3 and 1, my lord.
3 and 1.
Yes.
Whether any substantial question of law is involved in these suggested questions?
My lord, see, this issue number 3. Issue number 3 regarding, my lord, admittedly, my lord, the violation of the order 26 rule 9.
So, this
issue
one,
number,
question number 1. This has
It-
to be
it's
decided
covered-
on the
no, no.
basis of the facts.
all this comes in issue number 3, my lord. Issue number 3, my lord. Substantial question number 3, my lord. This is the most vital issue, my lord, here, my lord. Admittedly, the appellate court has overlooked on this one. Despite appreciated, yes, service necessary, there is a boundary dispute. Despite this, my lord, convinced on this point, my lord, and without commission, my lord, without verifying the records, my lord, without the boundaries, we are inserting that amended date, my lord, we have increased the not and then declared void of our dates, my lord. That is the question involved, my lord. There one question subsequent at this stage, my lord, I'm praying before this court, my lord. This is number question number 3, my lord. Admittedly, Order 26, Rule 9 involved. In my support, in fact, Lordship, I have brought some citations, latest citations of the High Court and all the Apex Court on this point, my lord. If the subsequent question 3 answered, my lord, my whole question, everything is come on this point only.
No, that's all right, but how do you establish that at a relevant point of time,
My lord.
survey was going on and it was
No, my
incomplete
lord.
in
Here
respect
in this
to
case, my lord, appellate court lordship does, I have seen the issue number 4 discussed, my lord, that admittedly, the appellate court also admitted there is a boundary dispute, my lord. Just presume then, my lord, again, I look to read the specific paragraph, my lord. I'd like to take trouble your lordship again, my lord. Page 70, my lord. Only 2 paragraphs I like to read again, my lord. 9.1.18 paragraph. The defendant respondent admitted that they were not having the land under the dock number 686 patta number so and so in the original sale deed, and the same was included by way of amendment without changing the boundary. But the inclusion of any new dock clearly extended the land to further north, and thus there is a chance, my lord, only a presumption, there is a chance of inclusion of the land of the appellant plaintiff who is shown to be in the northern boundary of the question deeds. Hence, I am of the considered opinion, my lord, that the plaintiff appellant could successfully show encroachment over his land, and there is necessity of survey of the common boundary of both the parties, and accordingly the present issue ought to have been decided in affirmative. That is the question. But so, my lord, on presumption, it is held that there is a chance of inclusion. And next paragraph, it said it is a survey's necessity. So order 26 rule line is very much clear on this point, and order section 75 of the CPC, my lord, on this point. And this honorable court, sorry, my lord, other high courts and the honorable apex court clearly decided on this point where there is a boundary dispute. The infant, my lord, if both the sides fail to make any application for the commission, the so moto in fact court may exercise this right, my lord. But in their case, my lord, appreciated there is a boundary dispute, and under presumption it is stated might be included. So very next paragraph here said yes, survey is necessary. Then why survey is not been done? After survey, the court after satisfying yes, there is no encroachment. Then our deed, as it is, the amended deed could not be interfered, my lord. But interfered.
You were referring to order?
Order 26 rule 9, my lord, and section 75. CPC, my lord. And lordship, if lordship permits me, I'd like to show some citation I have brought, my lord.
Citation on the point of framing of substance.
Yes, yes, my lord. So, my lord, I'm only letting this point, my lord. My whole deeds, my lord, I inserted only the dock number 660. When I purchased this land by through sale deeds 2009, my lord, accidentally, my lord, we have specifically mentioned, my lord, even they have not denied. In the plain paragraph 9, they have said this, my lord, that so far that deed is concerned. Later, when we amended, we just inserted only dock number 686, my lord. That is the only, whether the dock number, I think the 686, whether we have increased the land, this is the question, lad. So far as therefore, service necessary. And initially, trial court also framed so far as survey on the issue of survey, my lord. Appellate court also decided on this point, although appreciate the service necessary, but without surveying, my lord, our deeds has been declared void and cancelled, my lord.
What issue was framed by the learned trial court?
Yes, my lord. Yes, yes.
On this point?
Page 38, my lord. Issue number 4. And it is also the prayer of the plaintiff, in fact, there's issue prayer number 3.
And what is the finding of the trial court?
Yes, my lord. Trial court finding, lordship will find it. Page 41, paragraph 10. May I read the paragraph, my lord?
Yes.
This issue relates to the question as to whether the plaintiff is entitled to relief of survey of southern boundary of Schedule 2 under Schedule 1 to separate the area of Schedule 2 land. The plaintiff in his pleading as well as in his evidence has stated to purchase land in different ducts and pattas from the performer defendants number so and other vendors, and his witness also supported him in that regard. However, the plaintiff has failed to adduce evidence that he purchased the lands from those vendors. He has failed to submit any such sale deed in support of his claim. Although the defendants failed to cross-examine the plaintiff, yet the burden is upon the plaintiff to prove that he owns the Schedule 2 land and the land of the Schedule 2 is encroached upon by the defendants. The plaintiff has submitted the copies of sale deeds which were executed by his predecessors and original owners. He has failed to show the present British position, and perusal of the copies of the Jamabandi reveals that the predecessors of the defendant vendors are also recorded pattadars in the said patta land. It is not made clear by the plaintiff as to who got how much share in those duct of land, hence the issue is decided in negative. Appellate court held it. So for regarding this boundary dispute concern, survey is necessity. But despite exercising that provision of CPC, my lord, our deed declared void and cancelled, my lord.
Okay, we'll see and pass the order. You submit the
citation? Yes, my lord. My lord, the relevant paragraph I would note down below.
Item 47.
Obliged, my lord.
Item 47.
May I please, your lordship? Lordship, may kindly pass over for time being, lordship. My senior is in another court, your lordship.
Item number 20 and 21, matters for orders.
May it be pleases your lordship, early morning, your lordship, I made mention, your lordship, on behalf of you, Sharma, he's not well, your lordship. So any date may be given, your lordship, after 1 week, your lordship.
Yes, any objection?
Lordship, in item number 21, Lordship, the petitioner is suffering from illness, Lordship, is seriously ill, Lordship. And your Lordship had order dated 27/6, Lordship. Almost 1 month ago, Lordship, is directed that the finance has already accorded approval. Now, one post is required to be created and provincialize the service of the petitioner. So that inspection, Lordship, he is seriously ill, Lordship. Send some documents also, medical document, but I leave it to your lordship. Only thing is that he's seriously ill and suffering from it. So due to lack of money, lordship, he could not even getting the treatment, lordship.
No, he has already received 3 months salary.
No, item number 20 has received. 21, I am lordship, item number 21, last order may kindly be perused. 27/6.
What is the present status of that proposal pending before the finance department?
Finance. Yeah.
Already.
We are pleased the instruction.
24/6/2025. Instruction is there on that.
Okay.
It might be.
So madam, why don't you obtain the instruction?
He'll be appearing, your lordship.
Regarding this present status of the creation of the post. Finance has already accorded approval.
You Sharma had appeared in this matter, your lordship, and he is well known, your lordship.
No, that's
to
all
this,
right.
your lordship.
Mr. Soma is absent,
Maybe
but
given your
you
lordship
can
after
obtain
1
the
week.
inspection. You can obtain the inspection.
Lordship, then I can do, your lordship. As he is earlier submitting, your
That's all
lordship.
right, but today it may not be possible on your part. Day after tomorrow,
Yeah. Monday, your lordship,
Monday.
Monday.
Part Mr. Islam, learned counsel for the petitioner in WBC number 3090 of 2024. Ms. Sharma, also heard Ms. Das, learned counsel, appearing on behalf of Sir Sharma, learned standing counsel for the higher education, secondary education department. That Mr. Soleha, learned standing counsel for the finance department. Ms. Das submits that this matter is being looked after by Mr. U. Sharma, and he is not present in the court on account of his illness, and she prays for listening the matter on next Monday. Wednesday. In the meantime, Mr. Das will obtain necessary instruction regarding the present status of each of the post to accommodate the petitioner here in this case. Please record it.
In item number 20, Lordship, a proposal has been sent for area salary of the petitioner.
There also you obtain instruction. Part Mr. R. Islam, learned counsel for the petitioner, and Ms. Peters, learned counsel, appearing on behalf of Mr. U. Sharma, learned counsel for the petitioner. List this matter on next Monday, Wednesday, and in the meantime, Ms. Das, learned counsel, appearing on behalf of Mr. U. Sharma, learned counsel for the respondent contemptor, shall obtain necessary instruction in respect of in respect of the present status of the proposal regarding payment of arrear salary of rupees 6,66,400. Which the petitioner is entitled on next step.
Obliged.
22.
Your Lordship, on the last date, LCA was called for. However, as per the office note dated 21st July, the LCA has not been received yet, Your Lordship. Your Lordship, this appeal was admitted on 19/4/2021. But in the stay, only notices were issued. However, now, Your Lordship, execution case has been filed by the claimants in the lower court, and the next date has been fixed on 25th of July, that is day after tomorrow. So we are pressing for stay in this matter, Your Lordship, and we are also ready to deposit 50% of the awarded amount.
50% of the
Awarded amount, Your Lordship.
Is there any IA?
Yes, IA 778.
Third is Diani, learned counsel for the appellant. In MSc appeal number 100,021. Miss Diani, learned counsel for the appellant referring to office note dated 21/7/2025 submits that the LCR has not yet been received. Accordingly, it is provided that registrar shall issue reminder to the learned tribunal for transmitting the record without further delay. In IA, you take down IA number 778 of 2021. This interlocutory application is prepared by the applicant for staying the judgment and award dated 28/9/2018. Was by the learned member motor accident claim tribunal Tinsukia in MSc case number 81 of 2014. Ms. Liani, learned counsel for the applicant submits that the applicant has preferred to an MSc appeal, and the same has already been admitted by this court, and the record has also been called for. And in the meantime, the respondent opposite party herein has instituted one title execution. The one execution proceeding. What is the number?
Your Lordship, 8 of 2018, miscellaneous. Your Lordship, 8 of 2018. Ms. J, 8 of 2018.
Ms. J, case number 8 of 2018. And the next date is fixed on
25th July.
25th of July 2025. And as such, there is a requirement for staying the interim judgment and award, and that the applicant is ready to pay 50% of the awarded amount before the registry of this court. What is the awarded amount?
77,000.
But having heard the submission of learned counsel for both the parties, and learned counsel for the applicant, and also considering the facts and circumstances on the record, operation of the interim judgment and award dated so and so stands state till returnable date, subject however to payment of 50% of the awarded before the registry of this court within a period of 3 weeks from today.
Your Lordship, they may not be permitted to withdraw until further orders of this honorable court.
You first deposit the amount, thereafter we'll.
What's your objection?
23. May I please, Your Lordship? My lord, in this case, my lord,
Yes.
may I please, Your Lordship? My lord, in this case, my lord, wife, my lord, paying for transferring one, my lord, the restitution of conjugal rights case, my lord, from.
Who is for the other side?
My lord, the other side, my lord, service is completed but not appearing. It is pending before the, my lord, district judge Hailakandi, and she is paying the same to be transferred to the, my lord, family court, Kachar Silchar. She has a, my lord, girl child, and recently the, my lord, Court of Subdivisional Judicial Magistrate passed one judgment in a domestic violence case, my lord, granting some sort of maintenance, 6,000 each, my lord. Wife, my lord, petitioner before your lordship, and to her child, my lord. He is a police constable, my lord. And to frustrate, my lord, this judgment, my lord, he has filed this restitution of conjugal right case, my lord, page 19. He is intending that, my lord, if once somehow, my lord, she is taken to her, my lord, house, my lord, then this judgment will be infracted upon. This is his strategy. only.
So what is the distance between Hailakandi and Silchar?
My lord, it is around, my lord, 50 kilometer, my lord.
50.
50 kilometer.
And what is the ground?
My lord, ground is that, my lord, she has a, my lord, minor school going child, my lord, with her, my lord.
Minor?
School going, my lord, child is there, my lord.
This is the only ground.
Yes, my lord, paragraph 5, my lord, I have stated that, my lord, the petitioner has submit that admittedly, my lord, marriage was solemnized at parental house of the petitioner and the impugned suit for restitution of conjugal right has been filed on the ground that the petitioner is not returning from parental home of Kachar district. Therefore, the cause of action has been arisen under the jurisdiction of family court at Kachar, Silchar, but the case has been filed by the respondent in the court of learned district of Hailakandi, which has no jurisdiction. Moreover, the petitioner cannot move from her parental house, leaving her school-going child there. There is no direct bus service from her parental house to Hailakandi. To reach Hailakandi, the petitioner has to go to Silchar first, then to Hailakandi, which will be more than total 140 to 150 kilometer per day journey. to contest
Mr. Bormia, apart from this ground number 1, school going children, do you have any other ground?
Yes, my lord. This is, my lord, jurisdictional matter is also there, my lord. He is claiming that, my lord, she is not returning from the her parental house, my lord. The obviously, my lord, cause of action is also arisen, my lord, at, my lord, Kachar district, my lord. And her all the witnesses are also there in the, my lord, Kachar district, my lord. I have stated, my lord, at paragraph 5 of the petition, my lord.
Okay, heard Mr. A.M. Bormia, learned counsel for the petitioner. Person to order of this court dated 16/7/2025. An office note is being put up by the registry of this court. And it is stated that till date, no kalatnama has been filed on behalf of the respondent. This application under section 24 of the Code of Civil Procedure is preferred by the petitioner for transferring PES, which in bracket R, case number 5 of 2022, pending in the Court of Learned District of Hailakandi, to the Court of Learned Principal Judge Family Court, Kasar's Resort. Mr. Bormia, learned counsel for the petitioner, submits that the petitioner is the wife of the respondent. And their marriage was solemnized in the year
My lord, it is solemnized, my lord, that my lord, on 20/2/2011.
on 20th to 2011.
And child was born on 31/12/2013.
After the marriage, they resided together as husband and wife. In which place they resided together?
Yes, my lord, it is Hailakandi, my lord.
At Hailakandi. Then where the marriage was solemnized?
My lord, it was Hailakandi, my lord. At her residence at my lord Silchar, my lord. It is, my lord,
The marriage between the petitioner and the respondent was solemnized at
Niche Fulbari Part 2.
in the parental abode of the petitioner. And they were blessed with one female child on 31st of December 2013. And thereafter, marital discord surfaced between the parties, and then the respondent herein has instituted one divorce, the one title suit, which will get our case number 5 of 2022 before the Court of Law that this is as Hailakandi. Mr. Borgoya further submits that the petitioner is presently residing at Silsor, and on the ground of convenience, security, and jurisdiction, and for the interest of justice, the aforementioned case required to be transferred from the Court of Learned District Judge Hailakandi to the Court of Learned Principal Judge Family Court at Kasar Silsor. Mr. Borgoya further submits that the female child of the petitioner is now studying in class. In which class he has been studying?
My lord, class is not, my lord, she is now, my lord, about 13. In the year 2013, she born, my lord. Now, my lord, her age is around, my lord,
in school.
13 years.
Presently, she has attained 13 years. 13 years. And it is not possible on our part to attend the Court of Learned District Judge Hailakandi from our parental abode at Silsor. And under such circumstances, Mr. Borgoya submits that the title suit to get our case number 5 of 2022 has to be transferred from the Court of Learned District Judge Hailakandi to the Court of Learned Principal Judge Family Court at Kasar Silsor. Having heard the submission of Mr. Borgoya, Learned Counsel for the petitioner, I have carefully gone to the petition and the documents placed in record. And taking note of the submission of Mr. Borgoya, Learned Counsel for the petitioner, and also considering the present circumstances required. This petition stands allowed. It is provided that the PS within the Qatar case number 5 of 2022 pending before the Court of Learned District Judge Hailakandi stands transferred to the Court of Learned Principal Judge Family Court at Kasar Silsor. The petitioner shall obtain a certificate copy of this order and place the same before the Court of Learned District Judge Hailakandi, and on receipt of the same, the Learned District Judge Hailakandi shall make necessary arrangement for transmitting the record to the Court of Learned Principal Judge Family Court at Kasar Silsor. In terms of this, the petition is disposed of.
24.
Your Lordships. It's a criminal, civil revision applications, Your Lordships, challenging the interim order passed by the learned Civil Judge Senior Division, Soraidel, order dated 7/8/2023, whereby the rejection of the plaintiff's petitions filed under Order 23, Rule 1(3) for withdrawal of the suit. At the suit has been at the nascent stage. In the second day, they have filed an application for withdrawal of the suit that has been rejected. That is why this revision application has been filed, exceeding the order passed by this learned court below. The order which we have challenged before this honorable court, your lordship, would find page 76, Annexure K. Annexure K, page 76, operating portion is.
Yes, madam, you are appealing.
I am appealing on behalf of Mr. S.N. Tamoli Lordship. He is out of station.
S.N. Talukdar.
Yes, Lordship.
Different.
Can you argue the matter?
No, Lordship.
Sir, application for withdrawal, that is, we have challenged your lordships, which has been rejected.
Lordship, there are various provision for amendment. They can file amendment petition, Lordship.
No, but since the amendment is your lordship, too long, your lordship, since the order itself has not been passed in conformity with the provision of the act, the code. The operating portion is 79. The learned court below has taken a different view without considering the fact that there is a defect, formal defects, and other.
Whether the respondent has filed a affidavit.
No, Lordship.
There is a direction for filing affidavit.
Yes,
No,
Lordship.
I have filed we have filed affidavit, your lordship. This honorable court had passed the direction before to us, your lordship, to specific ground mentioning for why the application filed under the Order 23, Rule 1, Rule 3, your lordships, has been withdrawn. We have stating in our affidavit the grounds, the defects in the said suit, title suit.
Lordship, which time will be given for filing the plan?
We have filed an affidavit in way back in 2024.
No, affidavit by the respondent. Pardon me, sir, H. Barua, learned counsel for the petitioner. And Miss, your good name, please?
Miss A. Begum.
Miss
On
A.
behalf of
Begum,
Mr.
learned
S.N.
counsel. Appearing on behalf of Mr.
S.N. Tamoli.
S.N. Tamali, learned counsel for the respondent. Ms. Begum submits that conducting counsel Mr. Tamali is out of station.
Yes, Lordship.
Is out of station and she prays for and as such she prays for adjournment of the matter. And also she prays for granting 2 weeks time to file objection in this petition. Where is accordingly allowed, prays is the matter. After 2 weeks.
There is an interim order that day.
Interim order was earlier set contact.
Lordship. 25.
I am sorry, when I handicap my lord, cannot remove my cover. So my lord is the last order. This is on 25/6, my lord. There is a clear observation of the honorable court. Why this is not maintainable, my lord, and I have submitted this is not maintainable at all. And the lordship has given a direction to obtain this, to furnish a certified copy of that. On that day, my lord, I am not able to produce the certified copy.
May I please lordship, I pray for adjournment for the day, lordship, my senior is.
Not maintainable, my lord, is unnecessary, my lord.
Yesterday, lordship. Okalatama filed yesterday, lordship. Mr. A.R. Sheikh, the lordship. He is unable to today, lordship, some personal difficulties. He newly engaged lordship in this case.
This is nothing but a delayed practice. One of the earlier occasion, the same advocate is appearing now, the advocate is changing. This is nothing but a delayed practice, my lord. This order is very much clear. This is not a maintainable because the original title, so this has been dismissed. And that is gone on appeal. Appeal also dismissed, my lord. After that, what is the meaning of the continuing this interlocutory applications, my lord? These cannot be maintained. Unless the, my lord, tree is not there, how they can eat the fruits?
Okay, let Mr. Sigler remain present.
there
When
is-
he will be available?
Day after tomorrow, Lordship.
Day after tomorrow. Day after
Oh,
tomorrow.
my lord.
Mr.
SI Talukdar.
S.
I Talukdar.
S.I. Talukdar,
On behalf of Ministry.
Learned Counsel. Pardon, Mr. S.I. Talukdar, Learned Counsel, appearing on behalf of Mr. S.I. Sigler.
A.R. Shikdar.
A.R. Sigler, Learned Conducting Counsel for the petitioner, and also pardon, Mr. P. Mohanto, Learned Counsel for the respondent. Mr. Mohanto, Learned Counsel for the respondent has produced one order passed by the Learned District Judge Kamru Ben Guwahati entitled Appeal number 19 of 2024. And on the basis of the said judgment, Mr. Mohanto submits that this petition become infructuous. However, the Learned Counsel appearing on behalf of Mr. Sikar submits that the matter may be listed day after tomorrow as Mr. Sikar is not present before the court today. Accordingly, it is provided that rest shall list the matter on day after tomorrow.
On Friday, my lord.
Friday, you want to take it?
My lord, I will provide my lord one photocopy, my lord, I will take after that I will.
26.
Master.
Well, this is a transfer petition from Guwahati to Barpeta. I am for the wife. And on the last occasion also the advocate for counsel for the respondent not appeared. So in the meantime, my lord, the wife, the petitioner has already filed a divorce case at Barpeta. And next day's date is at 29th of 7 for conciliation. The case filed by the respondent come petitioner at Guwahati is for restitution of conjugal rights. So if that case is to maybe transferred to Barpeta, the cases will be taken together and could be disposed accordingly, my lord. My grounds are, first ground is that the petitioner wife has no mother or father alive. She resides with her brother, who is also a government employee, and it is hard for her to come to Guwahati and conduct the case before the family court because at Guwahati family court, each and every day, the personal appearance of the petitioner is absolutely necessary, my lord. Second ground is as distance.
And that's all right, but the counsel for the respondent is absent. They
Last
filed
occasion also they did not appear. Today also, in spite of listing the case
they
with
have
their
filed
name.
objection in this petition.
Yes, ma'am. So their objection mainly on 2 points. First point is that
We'll hear you, but not today. We'll list another. We'll direct the receipt to list the matter on another. Heard Mr. D. Kenneth, Learned Counsel for the petitioner, none appears for the respondent not called. List the matter after a week. In the event of subsequent non-representation of the respondent, appropriate order shall follow.
Well, intent may be
Interim order pass order shall continue.
27.
Right, this is lordship, this is an application for condonation of delay of 857 days in filing the application for setting aside abatement on the death of respondent number 2, my lord. Notice was issued to the legal heirs of the respondent number 2, but none has appeared, my lord.
Respondent number 1.
Whether service completed in
Service
respect of other-
completed, your lordship may, order dated 16/7/2025, may your lordship has passed the order.
So any objection?
No, lordship.
No objection. You have filed a wakalatnama here.
Lordship, I am appearing on behalf of YS Mannan.
He is appearing for the respondent number 1.
Respondent number 1.
1. Respondent number 2 died.
2?
2 died. On behalf of YS Menon, I am appearing.
You have the instruction to appear.
Senior is
Where?
next.
All right.
My lord, in this case, service completed, my lord. If you also admitted, my lord. Maybe fixed for hearing in the next week, my lord.
My lord, records were called for. Wide order.
I see.
Records not received?
No, my lord. As per office note dated 18/7.
18?
7, 2025.
Or Mr. S. Soikia, learned counsel for the appellant, and Mr. G. Imtiaz, learned counsel for the respondent. Office note dated 18/7/2025 indicates that LCR has not yet been received. It is provided that raise is a lesser reminder to the learned courts fellow for transcribing the record without further delay. This is the matter after 2 weeks.
Right.
After 2 weeks.
Deeply obliged.
My lord, in this case, lordship, proceeding has already been stayed, lordship, and we are directed to take Dusty on the respondent. There are 2 respondents in this case. Already Dusty has been served on them. That has also been indicated in the last order. Today I've seen that possibly they have entered appearance on behalf of respondent number 1 and 2.
Lordship, I'm for 1 and 2. Sometime maybe granted lordship, we have to file our response in the meantime.
File?
We have to file our response.
You have filed or you will
have to
file?
file, lordship. Sometime
Will
is-
file.
Yes.
Okay. Heard Mr. Ganguly, learned counsel for the petitioner, and Mr.
BP Sharma,
BP Sharma, learned counsel for the respondent number 1 and 2.
lordship.
Mr. Sharma submits that he may be granted some time to file objection. Bail is accordingly allowed. This is the matter after
Lordship,
1 week.
Lordship, in the mid of lordship, August, lordship.
After 2 weeks. After
Till then, the
interim order password is continue.
33.
Lordship. Lordship, services has been done in this case actually. This is one condonation of delay petition is also there. In the Dusty has been done. Here actually the thing is that the matter is that the visitation right when we applied, actually the order was that the daughter was allowed to visit the parents only on the case date. Family court which are the dates are going on. My saying as of today is actually because the opposite party has not yet come. I don't want to go for it. My only saying is that my daughter is going on a summer vacation, which is going to ending up in the first week of next month. So I may be allowed just 4 or 5 days to bring her. She stays at her hometown, Tihu, Nalbari. For the last 5-6 years, I have not, met her except on the dates actually, on 2-3 dates actually. I am the father of my own child, and here I pray to this honorable court, ki just allow her 4 to 5 days to bring her.
No. First, we have to dispose of this IA.
That's true.
IA is for condonation of delay.
That's true. That I totally agree here. But the thing is that on the same occasion, actually, on the same breath, actually, I want to state that since the summer vacation is going to expire, and I am the biological father, I just pray to this.
Without registering the appeal, it would not be possible on the part of this court to pass any order.
I just pray to this honorable court because as per the court decides, because the opposite party has not.
Why there is delay of 66 days?
66 days actually here the first one when we had applied
we had applied it as RFA, regular fast appeal. Then it went to the defective branch. Then it was said it will not be an RFA, it will be an FAO. Wow. Then again we withdrawn it, but there was also some mistakes in the FAO. That again we rectify it the same. So that process took us 66 days.
Okay. Pardon me, sir, I
Majumdar.
learned counsel for the applicant. This application under section 5 of the Limitation Act is deferred by the applicant for condition of delay of 66 days in filing the instant in filing the connected FAO first appeal against order against the order dated 7/9/2024 passed by the learned principal judge family court number 1 in Miss within bracket Z case number 75 of 2023. Mr. Majumdar, learned counsel for the applicant, submits that. Against the order dated 7/9/2024, the applicant herein has referred to on a regular first appeal on 4/11/2025, being RFA, which in bracket stroke 13099.
Filing number
stroke
maybe this is the
2024.
filing number.
But the same was put under objection on 14/11/2024 in the filing section. And later on, it was stated that appeal ought to have been preferred against the being first appeal against the order rather than regular first appeal. And thereafter, the FAO has been preferred, and there was defect in the said appeal. And thereafter, the defect was corrected. And in the meantime, there was delay of 66 days. And that the delay is not intentional, rather it is circumstantial. And as such, it is contented to allow this application. Having heard the submission of learned counsel for the petitioner, I have carefully gone to the petition and the documents that's on record. And it appears that the delay in filing the connected FAO is sufficiently explained. And as such, the delay stands condoned. In terms of this, I stands disposed of. And in view of the order passed in I number 7, the SC will proceed to register the FAO and place the same before the court as soon as practicable.
Obliged.
2 p.m. Item number 30.
Wait, please, your lordship. Now, in this case, the respondent number 3, who is the owner of the vehicle, their office is closed down. No one can be contacted. And paper publication appears to be the only way out. It's a construction company, KMC Construction. So I think I have to go for a paper. So they would be having office somewhere in Guwahati, but
No, what is your submission?
One law point is involved in this case, my lord. In my opinion, the appeal is not maintainable. Actually,
they admitted
the award was passed ex parte according to him. And he has filed a petition under order number Rule 13 for setting aside ex parte order. So that petition was rejected. So first, against that order, he will have to file appeal under order 43 Rule 3, my lord, CPC, to set aside that order. Thereafter, then the question of preferring appeal against the main appeal will come, my lord. There's a clear provision in the CPC that order 43
that
Rule
may
3.
be taken over the time here. It's already admitted. I have to now complete the steps. In the meantime, lordship, I'll take the steps. Matter can also be sent to conciliation if they find that everything is, in spite of the owner being absent, in spite of expertise, if there is some policy, then everything is okay. That is also underway. Both the process can go together. But owner has to be on the record, Lordship. Okay, we still do not know whether there is a policy or not.
You vote for respondent number?
Respondent 1 and 2 came in. 1.
1 and 2.
Under order.
So you want to take precedence upon respondent number 3?
Respondent number 3, Lordship.
Heard Mr. Goswami, learned counsel for the appellant, and Mr. Sharma for the respondent number 1. 2 has already been struck out.
2 has been struck out, Lordship.
Mr. Goswami, learned counsel for the appellant submits that he will take precedence upon respondent number 3.
Yes, sir.
By registered post with AD and also by usual process.
But there is an order to show my name in the court list, but it was not shown. There is an earlier order. to show my
Accordingly,
name in the
it is
court list,
provided that
but today it is not
recess
shown.
shall issue. No, the learned counsel for the appellant shall take precedence upon respondent number 3 by registered post with AD and also by usual process
Lordship,
from today.
Lordship, newspaper publication.
Paper
That's
publication.
because this will not find them. The address has changed. Earlier report. They shifted their office.
Okay. And he submits that he may be allowed to effect service upon respondent number 3.
And it should
by
be
paper
directed to show my name in the court list. madam.
Here is accordingly allowed. Accordingly allowed. Step be taken. Fixing the date on. No, for paper publication date.
More 8
August.
Because that might take a little time. I have to get the order from the High Court, then so about 2 months. Or maybe 45 days. That has to be published, and the other party also has to get some time to appear after a publication.
Then September.
Yes, sir.
Then SSL is the matter after.
Order maintainability may be kept open.
So my appeal has already been admitted.
Hello?
Appeal has already been admitted.
Maybe, but there is a provision in the order 43 rule D. They will have to file separate appeal. This is an appeal under section 74, not under section 43, my lord. 74 is against the main award, my lord. But they will have to file the appeal against the order passed by rejecting the petition under
That's all
order.
right, we will hear you. Also, let the service completed. Next step.
That is why I am submitting that the
Rest
maintainability may be kept open.
shall list the matter on 18th September.
Maintainability may be kept open, and the history may be directed to show my name in that court list. It was not shown. Earlier or earlier.
So Sharma, learned counsel for the respondent number 1 submits that though there is a direction of this court in the order dated 28/6/2025 to reflect his name in the cause list, yet the same has not been reflected. Rest shall do the needful in this regard. List according.
Standing item 1 for motion.
May it pleases your lordship. Your lordship, in this civil revision petition, the impugned order which has been challenged has been passed by the first appellate court, reversing the order of the trial court for return of plaint with a direction to be filed before the wakaf tribunal at Kamrup Metro, Guwahati. Now, lordship, the respondents as plaintiff filed title suit 52 of 2019 before the Court of Civil Judge Junior Division at Dhubri, seeking declaration of their right title interest, for confirmation of possession, for cancellation of our registration with the Wakaf, Assam Board of Wakaf,
and for correction of records. Now, as against that suit, we appeared and filed our written statement and counterclaim. Along with our written statement come counterclaim, we also filed an application under Order 7, Rule 11D, stating therein that the suit is barred by the provision of Section 85 of the Wakaf Act 1995, as the dispute pertains to determination whether the property is a Wakaf property or not. So the trial court, while exercising its jurisdiction under Order 7, Rule 10.
No, Mr. Ahmed, you see, the matter is listed today for motion.
Motion.
Yes. So today let notice go.
They have already appeared.
Yeah, appearing in.
There was actually a delay condonation
Any
petition.
objection here?
Yes, Lordship.
You have filed objection.
Lordship, already the order was passed long back and thereafter the title suit is going on, Lordship. There was no stay, Lordship.
No, that's all right, but you have filed your objection or you will be filing?
No, Lordship, in civil revision
Revision
petition based
not
on
required.
these documents, I will argue, Lordship.
Okay. Where is the impugned order?
Impugned order starts from page number 79. The operating part is at page number 85. Discussion, decision, and reason thereof. Whether the order dated 19/12/2019, passed by the learned Munsif Dubri in Miss J number 96/19.
Page
is
number?
Page number 85. Lordship. Whether the order dated 19/12/2019 passed by the learned Munsif Dhubri in Miss J number 96/19 is sustainable in law and facts. At the outset, let me reproduce the relevant portion of the order passed by the learned Munsif, whereby the learned Munsif has held that the civil court has no jurisdiction to entertain the suit under consideration. The relevant excerpt of the order runs as follows. Case record reveals that the Assam Board of Wakaf has already registered the suit land as Wakaf property. Therefore, it is clear that as per provision of law as laid down under Section 7/85 of the Wakaf Act 1995, the civil court has no jurisdiction to decide whether the suit land is Wakaf property or not. Unquote. Now, from the aforesaid observation of the learned Munsif, it is found that the learned Munsif has held that the suit property is a Wakaf property and had returned the plaintiff on the ground of legal bar as adumbrated in respect of Wakaf property under the various provisions of the Wakaf Act 1995. So that being the position, now let us see whether the aforesaid observation of the learned Munsif is justified in law and facts. Now, if we peruse the pleadings of the plaintiffs or appellants, we find that the plaintiff has prayed for declaration of his right title interest as well as for the confirmation of possession in respect of the suit property on the basis of his continuous possession on the strength of abandonnama issued by the Revenue Authority in the year of 1994 after due compliance of legal procedure and receipt of necessary fees or duties from the plaintiffs or appellants. Whereas the respondent or defendants, on the other hand, claims the suit land on the basis of an order passed by the CEO of Assam Board of Wakafs in the year 2013, declaring the suit land as Wakaf property. However, the bare perusal of the relevant order of the Wakaf Board marked as Annexure 1, it appears that the suit land has been registered as Wakaf property merely on the basis of an application and khasara, which is a disputed document, without proper inquiry and without following the due procedure as laid down under Chapter 5 of Wakaf Act in the letter and spirit. Moreover, if we see the materials available in the case record, we will find that the claim of the appellant over the suit property is on the basis of abandonnama issued in the year 1994, that is prior to the creation of Wakaf Act. Not to speak of the aforesaid order passed by CEO in the year 2013. So in view of the matter, I am of the considered opinion that the appellant's plaintiffs has raised a tribal case, bona fide dispute, so as to decide whether the suit land is a public graveyard. And hence, in my considered opinion, the civil court has got the jurisdiction to decide the claim of the plaintiff or appellant as made in the title suit. Hence, under the above facts and circumstances, I am of the considered opinion that the observation made by the learned Munsif number 1 Dhubri was not justified in law and facts. Accordingly, the order dated 19/12/2019 passed by the learned Munsif Dhubri is hereby set aside and in consequence the appeal is allowed on contest with cost. Send back the case record, so and so. So this was the impugned order that was held. And my submission before the Honorable Court is that it is outrightly perverse. It is beyond the jurisdiction of a court which is exercising its jurisdiction under Order 43, Rule 1A, to come on a finding of fact that one document is genuine and the other document is not genuine. Moreover, no evidence has been laid in this case. The case was at the stage of pleadings when a petition was filed under Order 7, Rule 11D. The court exercised its jurisdiction under Order 7, Rule 10 and returned the plaint to be filed before the appropriate tribunal, that is the wakaf tribunal. Now that was the limited question that is to be decided whether the return was proper or improper. But the learned court below has gone into the merit of the case and has given a finding of fact to the effect that the wakaf, that is certificate that has been issued by the CEO, that has been procured without inquiry and without following the due procedure as laid down under Chapter 5 of Wakaf Act in letter and spirit. So this is very much perverse. That order I have enclosed here along with this revision petition at page number 65. At page number 65, that order is there, issued by the Chief Executive Officer, Assam Board of Wakaf, Hizubari, Guwahati 38. Peruse the application dated so-and-so, submitted by one Asir Ali Ahmed, son of so-and-so, village so-and-so, for registration of Rahmania Kabristan, Jhagrar Bar, Part 4, with the Assam Board of Wakafs under the provision of the Wakaf Act 1995. Also peruse the letter dated 5th July 2013, submitted by Abdul Karim BA LLB, Senior Advocate and President, Management Committee of Hamidabad Wakaf State, requesting the board to register the above public graveyard of Jhagrar Bar, Part 4, measuring land 1 Katha 17 lesas in Dag number 363 as per resolution of Jhagrar Bar Rahmania Kabristan Committee dated 18/5/2013. Also peruse the copy of the Khosara of village Jhagara Part 4, wherein the possession of the land measuring 1 Katha 17 lesas under Dag number 363 has been recorded in the name of the Kabristan. On perusal of the statements in application stated above and the records in the Khasra, it appears that the land in question has been used from time immemorial as Muslim Kabristan and therefore may be called a wakaf by user. In view of the position stated above, the Kabristan known as Rahmania Kabristan Jhagrar Bar Part 4 with land schedule below is hereby registered with the Assam Board of Wakafs as wakaf by user under the provision of Section 36 of the Wakaf Act 1995. The particulars of the wakaf and the mutawali of the said wakaf are shown as below. This is the schedule particulars of the mutawali. Now, Lordship, this document has been, by mere perusing it, has been decided to be not in compliance with Chapter 5 of the Wakaf of 1995. So this is a finding of fact. An appellate court giving a finding of fact based on no evidence. Because we have not given the opportunity, even at the stage of the suit, to lay evidence. That evidence part, the hearing part has not yet commenced. There is no evidence on record. So by mere perusing a document, if someone can say about whether it is genuine or not, or whether it has been done in compliance with Chapter 5 of the Wakaf Property Act 1995 or not, then that finding would be perverse. And other than that, we also brought it to the consideration of the learned court below that another suit was filed on the same subject matter in the year 2013 by the petitioners here. They filed a suit for declaration of their right title interest, for recovery of possession against the same respondents, and for permanent injunction. That suit was in the wide order dated 9/9/2016. That was the plaintiff was returned with a similar direction, the same to be filed before the Wakaf Tribunal at Kamrup Metro, Guwahati. And we filed that. And that is the pending disposal. It is at the stage of cross-examination of defendant witness. And the respondents have appeared in that suit. They have filed their written statement counterclaim. They have cross-examined the plaintiff's witnesses. And now the DW1 even has been partly cross-examined. So already there is a proceeding before the Wakaf Tribunal that is going on. In spite of that, another suit has been filed at Dhubri. And the earlier order of return, that is 9/9/2016, that was passed by the Court of Civil Justice Senior Division at Dhubri, that was never assailed before any appellate or revisional authority. That has attained finality. And in that aspect also, this is not maintainable, because again, the Court of Civil Justice Senior Division is sitting in revision of its own order in a way, because the subject matter is the same, the parties are the same. Now, Lordship, I beg to place Section 85 of the Wakaf Act. It has been reproduced in paragraph 13 of my petition at page number 15. I've reproduced it therein.
Yes.
Section 85. Bar of jurisdiction of civil courts. No suit or other legal proceeding shall lie in any civil court, revenue court, and any other authority in respect of any dispute, question, or other matter relating to any wakaf property, or other matter which is required by or under this act to be determined by a tribunal. In very clear terms, it raises three things. One is that dispute, question, and other matter relating to wakaf property. Dispute, when it is a dispute between two parties, both parties are agreeing that it is a wakaf property, that kind of dispute. Question as to determination whether the property itself is a wakaf or not. Suppose one party is agitating, the plaintiff is agitating, it is a wakaf property, defendant is denying. In that aspect also, that question has to be determined by the wakaf tribunal, and other matter relating to any wakaf property, whether it be a tenancy matter, lease matter, any other matter. Wakaf or wakaf property, that has to be decided. So it is a clear bar. It is a clear bar that civil courts shall not exercise their jurisdiction. And that is the reason why Section 83 of the Wakaf Act empowers the Wakaf Tribunal to act as a civil court, and also the proceedings to be governed by the Code of Civil Procedure 1908. So what is the problem with the respondents is that they are contesting the suit before the Wakaf Tribunal also, and they're going back home and then filing a suit therein also. And without challenging the previous order of the same court, that is Court of Civil Justice Senior Division at Dhubri, that this should be returned and it should be filed before the Wakaf Tribunal. Lordship, I would like to place some judgments on Section 85. The first one, there is a Haryana Wakaf Board versus Mahesh Kumar, reported in 2014, 16 SCC 45. Kindly consider paragraph number 13. The present suit was instituted, para 13 at page 49. The present suit was instituted in the year 2000, that is after the Wakaf Act 1995 came into force. Therefore, the present case is not covered by exception to Section 7(5) of the Wakaf Act. Thus, on a plain reading of Section 7 read with Section 85 of the Act, it becomes manifest that wherever there is a dispute regarding the nature of the property, namely whether the suit property is Wakaf property or not, it is the tribunal constituted under the Wakaf Act which has the exclusive jurisdiction to decide the same. We need not delve into this issue any longer, inasmuch as in a recent judgment by this very bench of this court in Bhawarlal versus Rajasthan Board of Muslim Wakaf decided on so and so, this court took the same view after taking note of earlier judgments on the subject, namely Sardar Khan versus Syed Nazmul Hasan, Ramesh Govindram versus Sugra Humayun Mirza Wakaf. This view has been reaffirmed in Akhode Jumayat Palli Paripalana Committee versus PB Ibrahim Haji. So it is a settled position that whether the question that it is a Wakaf property or not, that itself has to be decided by a Wakaf tribunal. The civil court cannot exercise jurisdiction on that. The second judgment, Rajasthan Wakaf Board versus Devaki Nandan Pathak and others, reported in 2017, 14 SCC 561. Kindly consider para 24. Section 83 of the Act empowers the tribunal to determine any dispute, question, or other matter relating to a Wakaf or Wakaf property under this Act. Section 85 of the Act, which deals with the bar of jurisdiction of civil court, provides that no suit or other legal proceedings shall lie in any civil court in respect of any dispute, question, or other matter relating to any wakaf, wakaf property, or other matter which is required by or under this act to be determined by the tribunal. I skip and come to para 27. In the first place, the main question involved in the suit was whether the suit land is a wakaf property or not. Plaintiff says that it is a wakaf property, whereas the defendants say that it is not the wakaf property, but it is their self property. This question, in our opinion, can be decided only by the tribunal and not by the civil court, as has been decided by this court consistently in Ramesh Govindram versus Sugra Humayun, Wakaf, and Bhawarlal and another versus Rajasthan Board of Muslim Wakaf and others. So that is a settled position. Then kindly come to the next judgment, that is Telangana State Wakaf Board and another versus Muhammad Muzaffar. I am relying upon paragraph number 18. The learned counsel for the appellants has, on the other hand, drawn our attention to other decisions of this court on the same issue. In case of Board of Wakaf so and so, and in case of Haryana Wakaf Board, this court has held that the question as to whether a property is Wakaf property or otherwise is exclusively determinable by the Wakaf Tribunal after enactment of the Wakaf Act. The decision in the case of Punjab Wakaf Board versus Sham Singh Harike is also referred by the learned counsel for the appellant to contend that in order to determine as to whether there is a bar on the jurisdiction to the civil court in relation to the provision contained in Wakaf Act, one is to ask the question as to whether the issue raised in the suit or proceeding concerned is required to be decided under the Wakaf Act 1995 by the tribunal under any provision or not. And if the answer to that question is in the affirmative, the bar of jurisdiction of the civil court would operate. Then I am relying upon
Not necessary to multiply the decision.
Lordship. So the basic submission is that the civil court has no jurisdiction in view of section 85. And they have been continuing the suit at
So we
Dhubri.
come to this page number 65, annex of 4.
Page number 60.
The order of the executive officer.
Lordship.
So here there is an observation that it is being used from time immemorial
Time immemorial.
as Muslim
As a
Qabristan,
Muslim
and
Qabristan.
therefore it may be called as work by user.
Work by user under section 36. And this order has not yet been challenged. They ought to have filed a representation either before the Wakaf, that is the Assam Board of Wakaf, or they ought to have come before this court in a writ petition. They never did that.
Yes, madam, what is your case?
Wait, Lordship. First of all, Lordship, my learned friend has made a wrong statement that in my plaint there is a prayer for cancellation of the wakaf, Lordship. Lordship, kindly see the plaint which they have annexed. Page 32, Lordship.
30?
32, Lordship. Prayer portion, page 33.
Yes.
And this is the suit, Lordship, which is disputing in this case, Lordship. The plaintiff pray for declaration that the plaintiff suit be decreed against the defendants declaring their right, title, and interest possession over the suit land. That the confirmation of possession of the plaintiffs over the suit land be declared with their residence thereon. That the order of ASO of Dhubri Circle passed on 3/4/2019 be declared illegal and be set aside, and the name of the plaintiff be restored in Patta number 496, Dag number 363-560 of the suit land as described below. That the declaration be made that settlement of the suit land in the name of the plaintiffs for the suit land be declared bona fide, genuine, and valid. That the declaration be made that there is no qabristan in the suit land. That a permanent injunction be passed against the defendants, restraining them from entering into the suit land and from evicting and dispossessing the plaintiffs, demolishing their houses thereon. So there is no prayer for cancellation of wakaf registration, Lordship. There is no whisper about wakaf, Lordship. In this case, what happened, Lordship, I have stated in my plaint, categorically, I have stated the incidents which happened before the filing of this suit, Lordship, page 28.
Yes.
There are numerous lordship cases filed by the other side petitioner against this plaintiff's lordship. Para 9 lordship, that the defendant Asser Ali Master, who is the masterminded of creating troubles to the plaintiffs, filed a false case by case number 408/2011 and Midje case number so against the plaintiff along with ASO Dhubri Circle ADC and Collector Dhubri, but the title suit number 408/2011 was dismissed on withdrawal with cost of ₹2,000. But the cost amount was not deposited to the court and Midje case number so was dismissed on so. Thereafter, the petitioner filed misappeal 212 in the Court of Civil Judge Dhubri and withdrawal on 3/9/14 with cost of ₹1,000. That the defendant Asser Ali Ahmed again filed title suit 16/2013 against the DC Dhubri and ASO Dhubri Circle, which was dismissed on 9/9/2016 in respect to the suit length. That the defendant Asser Ali Ahmed again filed title suit 218 before the presiding officer Wakaf Tribunal. This 16/2013 suit was filed by them, lordship. It was returned to be filed before the Wakaf Tribunal, and then they filed after 5 years, lordship, 2018 title suit before the Wakaf Tribunal against the DC Dhubri, ASO Dhubri Circle and plaintiff Sabu Sheikh for the suit length, which was dismissed on 6/12/2018 on withdrawal. Again, that suit was dismissed, lordship, on withdrawal. Thereafter, they filed suit in the year 2021, lordship. And in between, lordship, the plaintiff petitioner who is possessing the suit land on the basis of an avantan nama from the government, lordship, got patta, and his patta was cancelled, lordship, on the basis of the complaint made by this petitioner's court. So he filed the title suit, this title suit before the civil court, lordship. With these prayers, there is no whisper about wakaf, lordship, cancellation of registration of wakaf, lordship. So this title suit was returned on the basis of an application by, and in this title suit, they have contested by filing written statement and counterclaim also. So they are admitting the jurisdiction of the civil court, lordship. Otherwise, why?
Where is that WS?
WS is there, lordship. Annexure 2, page 36. Not only written statement, they are not denying my claim. Again, they are praying their relief, lordship, before the civil court. So they are admitting the jurisdiction of the civil court, lordship. Page 36.
Yes.
Written statement come counterclaim on behalf of the defendant numbers 5 and 6. It was filed, lordship, in my 2019 title suit, and date of filing is, lordship, counterclaim page 49. Your lordship will find the counterclaim portion. It started from page 49. And last page, lordship, page 57, affidavit by Muhammad Asser Ali Ahmed, 2019. So they have already filed written statement, already, lordship, they have filed counterclaim also in my title suit that was pending there, and thereafter they filed an application for rejection of the plaint, lordship. Then instead of rejection of plaint, the learned Munsif has returned the plaint to file before the learned Wakaf Tribunal, which I have challenged before the appellate authority by way of misappeal, lordship, under order 43 rule 1A. So subsequently that order was passed, saying that it is not a Wakaf property. This issue can be decided by civil court, lordship. That impugn order is of the date 2019, lordship. The impugn order was passed. Page, your lordship, impugn order, that is 79. My learned friend has just read out the entire order portion, lordship. As page 79, I am just pointing the order, lordship, 9/5/2023. So since 23, they are contesting after remand of this suit to the original court, Munsif, lordship, they are contesting there. So without challenging this order, lordship, they already contested the title.
Page number?
79, lordship. The impugn order was passed on 9/5/2023. And only when before the wakaf tribunal, we raised a preliminary issue, whether this wakaf tribunal has jurisdiction to decide this case, lordship. Then after filing of our petition, they have moved this CRP along with a condonation application, lordship. So my submission is that, lordship, when they are contesting the title suit by way of filing written statement along with counterclaim, that means they are admitting the jurisdiction of the civil court, lordship. And lordship, when after remand also, lordship, by the first appellate court, they are contesting before the learned trial court. On 15/5, I have gone through some online orders, lordship. On 15/5/2025, defendant number 7, 9, 11, and 13 are represented. State is also represented. Plaintiff side has filed petition under order 22, rule 4, defendant number 11. So, lordship, defendant number 11 already died. Who is respondent number 9 in this revision petition? So, revision petition is also against a dead person, lordship. Page 4, your lordship will find the name of respondent Fazizur Rahman. Page 4 of this petition, whose name appeared in my plaint, defendant number 11, as Fazizur Rahman. Defendant serial number 9, Fazizur Rahman, in revision petition. And page 24 of my plaint, defendant number 11, Fazizur Rahman, son of late Keramat Ali. Here also son of late Keramat Ali.
Page number?
Page number 24, lordship, of my plaint, for which trial is going on now. 11, Fazizur Rahman already died, lordship. That on 15/5, we have filed substitution petition for defendant number 11. And here also, lordship, if their petitioner, lordship, their duty is to substitute this respondent number 9, lordship. So basically, this civil revision petition is on a dead person, lordship. One of the respondent is in the meantime died, lordship. And the second suit which is going on in the before the tribunal, lordship, the prayer of the second suit, your lordship will find from their plate, lordship. Annexure 11, page 93. That is title suit number 1/2021. In fact, which was initiated in the year 2011, and after withdrawal of 2 times, lordship, they have filed ultimately in the year 2021. The prayer your lordship will find 102 page number, lordship. In the aforesaid facts and circumstances, the plaintiff prays for a decree declaring the right title in interest of the Rahmania Kabarstan, that is the plaintiff number 1, over the Schedule A land, including the Schedule B land appended to the plaint. A decree for recovery of khas possession of the Schedule B land by evicting the defendants, their men, agents, assigns, attorneys, and materials from the Schedule B land. And decree declaring that the abandonment nama dated so-and-so by so-and-so, lordship, under the government of so-and-so is null, void, ab initio illegal, contrary to law, and not binding upon the plaintiffs. A decree for cancellation of the abandonment nama dated so-and-so. A decree for issuing precept to the office of the Deputy Commissioner Dhubri for cancelling or deleting abandonment nama. A decree for permanent injunction restraining the defendants, their legal heirs, successors. So basically their first prayer is that, lordship, a decree declaring the right title and interest of the Rahmania Kabarstan of the plaintiff number 1 over the Schedule land. For this, lordship, there is no dispute that it has to be decided by tribunal, lordship. There is no dispute, lordship. And these citations which my learned friend has submitted, lordship, these are correct, lordship. Any dispute for right title, lordship, and interest over wakaf property, that has to be decided by wakaf tribunal, Lordship. So that case, Lordship, we have raised a preliminary issue argument already concluded, Lordship. That case is pending at the stage of judgment, Lordship. When we raised that issue, then only this civil revision petition was filed, Lordship. And we have not challenged that order of Lordship returning the plane to the wakaf tribunal only because, Lordship, subsequently we have filed our application on the ground of preliminary issue, Lordship. So, Lordship, I am in this case appearing for respondent number 1 and 2. At this stage, your Lordship may issue notice to other respondents. There are some other respondents, and their duty is to, Lordship, substitute respondent number 9, and no Lordship interim protection may be. Only this is my humble prayer before.
Lordship, one thing I would like to point out.
Yes.
Lordship, at page number 23, their plaint, that is title suit 52 of 2019. The array of the parties, defendant number 3 is the Chief Executive Officer, Assam Board of Wakaf, Hizubari, Guwahati 38. The Chief Executive Officer has been made a defendant. Then 5th is Asir Ali, son of late Keramat Ali Sheikh, Mutawli of Rahmania Kabristan. A Mutawli has been made a party. Then coming to 6, these two itself shows that the Chief Executive Officer, Assam Board of Wakaf, and the Mutawli having been made a party in the instant suit, somewhere or the other, it leads to determination whether the property is a Wakaf property or not. And my learned friend has said that we have accepted the jurisdiction of the civil court because we have filed counterclaim along with our written statement. Now, before the Wakaf tribunal, the case which is pending, that is title suit 1 of 2021, they have also filed a counterclaim. That means they have also accepted the jurisdiction of the tribunal. Then why they are filing preliminary issues or why they have instituted this suit? They could have abandoned this suit. It would be ridiculous.
Okay, Madam, you were appearing for respondent number
1 and 2.
1 and 2. Mr. Ahmed, learned counsel for the petitioner, and Ms. As already learned counsel for the respondent number 1 and 2. In this petition under section 115 of the Code of Civil Procedure, the petitioners have challenged the order dated 9/5/2023 passed by the learned civil judge, senior division of February, in Miss Appeal number 3 of 2020. This to be noted here that I review judgment dated 9/5/2023, the learned civil judge, senior division of February, has set aside the order dated 19/12/2019 passed by the learned counsel of February, and allowed the appeal on contest with cost. Peruse the order, peruse the petition and the documents class and record, and also peruse the order dated 9th of May 2023. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with ADN also by usual process upon respondent number 3 to 15. However, no formal notice is required to be issued to the respondent number 1 and 2 since Ms. Sodori entered evidence and received notice. However, extra requisite copy of the petition by Mr. White in the course of the day. Lays the matter after 4 weeks.
Lordship, I may be allowed to file substitution petition.
Mr. Ahmed, learned counsel for the petitioner, submits that during the pendency of this petition, when this respondent number 9 suffered demise.
Lordship, that date exactly I am not aware. I can obtain the date, Lordship. Then, Lordship, the respondent number 9, no notice may be issued in this case. Your Lordship has already
Later on, Mr. Ahmed Learned Counsel for the petitioner submits that he may be allowed to file a substitution petition in respect of respondent number 9 who had already suffered demise. That is accordingly allowed, this is a less than a pair of 4 weeks.
And Lordship, the title suit may be stayed, till next date.
That
And
alone.
if the petitioner will be considered on appearance of the other side.
Deeply obliged.
Pending item 46 for admission.
On appearance to rest.
May it please your lordship.
Yes.
And this regarding my lord, provincialization of service of the petitioners. And petitioner this is the second time they post this honorable court. And my lord, your lordship kindly, my lord, earlier when I opposed this honorable court, and this honorable court, my lord, passed an order.
It's a model, the respondents to be absent now. The morning hours, they were, yeah. So, he will contact, wait for some time.
My lord.
Pending item 16 for hearing under the 21.
Lordship, item 16, I made a mention for listing, but some citations I could not obtain, Lordship. So
Okay.
some more time may be given, Lordship.
Okay. I thoroughly learned counsel for the appellant, press for listing the matter. After
Next.
one,
Yes, Lordship.
after one, fair look.
Obliged.
Item number 69.
Only 16.
Pending item 47 for hearing under the 41.
May I please, dear lordship? My lord, the substantial questions of law, my lord. We have filed, my lord, the memorandum of appeal, my lord, your lordship will file at page 9, my lord.
Yes.
Whether the title suit number 163 of 2014 filed by the respondent plaintiff for declaration of right title, partition and recovery of possession over the suit land without impeding the co-sharers of the suit land is maintainable. Hello, this is a suit for partition filed by one of the legal heirs of Hassan Ali, who is my brother. But for declaration of right title, interest, recovery of possession and partition of the suit land. Now, in a suit for partition, my lord, your lordship knows, my lord, that a share and possession of the parties to the suit are required to be ascertained. And my lord, the learned trial court, my lord, after hearing the parties and perusal of the evidence on materials on record, my lord, has came to a conclusion that the parties to the, my lord, the co-petitioners has not been implemented in the case, my lord, despite the specific readings of the my lord, the appellant in the written statement we are defendant in the suit, my lord. And therefore
You
the
show me
suit,
the written statement.
my lord's written statement.
Page number.
Page number, my lord, 23, paragraph number 5. Page 23, para 5.
Yes.
That late Hassan Ali enjoyed 3 bighas, 1 katta, 5 acres of land within the suit patta. Till this that said Hassan Ali died, leaving behind his behind him and one wife, namely Fatwa Bey, and 7 sons, Halaluddin, Bilal Hussain, Fazal Ali, defendant number Asghar Ali, Dulal Mia, Iman Ali, Asraf Ali. Defendant number 4's name is Jaigan Mesa, Haliman Nessa, Hawa Khatun, Rabina Khatun, and Aziz sole legal years. It is a fact that Fatwa has already been expired. Although the plaintiff made Fazal Haq, Asghar Ali, Iman Ali, and Haliman Nessa, Rabia Khatun as the parties, but plaintiff failed to make, this is the specific environment, failed to make made parties the said Dulal Mia, Bilal Hussain, Helal Uddin, Jayagan Nessa, Haliman Nessa, Hawa Khatun in the suit. Hence, the plaintiff's suit is bad for non-joinder of necessary parties. Now, my lord, your lordship kindly see, my lord, the trial court judgment. My lord.
Page number.
Page 42, my lord. Starts from page 42. Page 43 is the relevant parameter. Issue number 1A. Now, my lord, issues your lordship will find, my lord. Page 39. Page 39 are the issues, my lord. Lordship, kindly come to page 39. Page 39, my lord. Additional issue, whether the suit is bad for non-joinder of necessary parties. Page 39. Then, my lord, your lordship kindly come to the page 43. This issue has been discussed and decided, my lord. At the bottom, my lord, issue number 1, issue number A. That is the additional issue, my lord, whether the suit is bad for non-joinder of necessary parties. The defendant in their written statement have taken the plea that the suit is bad for non-joinder of necessary parties. They have claimed that all the legal heirs of Hassan Ali, who are the co-sharers, are not implicated in the suit. It is found that the bare reading of the plaint that the plaintiff has claimed share over 2 katta 8.5 acres of land as paternal property. The plaintiff have claimed at the time of death of his father, namely Hassan Ali, and had 3 bigha 1 katta 5 acres of land is the suit patta. After the death of the said land was amicably partitioned, and all is the legal heirs, and accordingly 2 katta 8.5 acre fell in his share. On close perusal of the evidence on record, I find no concrete evidence in support of the plaintiff. As the plaintiff have claimed title over the suit land on the basis of amicable partition on all the co-sharers, they are necessary parties to the suit. Again, as order 20 rule 18, a decree for partition of this is very important, my lord. A decree for partition and separate possession of his shares of co-owners can be passed by issuing a preliminary decree, and presence of all co-owners is a sine qua non for preliminary decree for partition. But in the instant case, the plaintiff have not implicated all the co-sharers as stated above. In fact, even after the defendants taking the specific plea of non-joinder of necessary legal heirs of Hassan Ali, the plaintiff did not make them parties to the suit by amending the plaint. The suit patta being a joint patta, the suit of the present nature cannot be decided in absence of the co-owners having interest over the suit patta, and accordingly, it is held that the suit is bad for non-joinder of necessary parties. But thereafter, they filed, the plaintiff preferred appeal. Appellate court set aside the decree.
How this issue was dealt with by the appellate court?
Appellate court said,
that they have purchased 2 bighas of land from the other co-owners. Now, my lord, that purchased land, whether they have purchased, from whom they have purchased, what is their share, my lord, whether they have ascertained their share, nothing discussed, my lord. The appellate court only said because they have purchased the, my lord, 2 bighas of land from the other co-owners, my lord. Therefore, it is not affected by the non-joinder of necessary parties. This is absolutely, my lord, perverse and unsustainable in law. Because, my lord, Order 20, Rule 18, your lordship kindly see, my lord, Order 20, Rule 18, my lord. Read with section 54 of CPC as well as section 101 of the, my lord, Assam Land and Revenue Regulation Act. All this act says, my lord, when it is a suit for partition, my lord, a preliminary decree has to be passed to ascertain the share of and possession of the not only the plaintiff but also the defendants, parties to the suit. That is what the mandate of the law, my lord. Order 20, Rule 18, my lord. Order 20, Rule 18, subclause 2. Well, this has been overlooked or ignored by the learned appellate court. These provisions of law, my lord, Order 18, Rule 2, if your lordship kindly peruse, my lord, Order 18, Rule 2, my lord. It says, my lord, decree in a suit for partition of property.
Order 18 rule.
Order 18, my lord. Order 18, Rule 2, my lord. Order 18, I may read Order 18, my lord. Where the court passes a decree for the partition of property or for the separate possession of a share therein. One, if insofar as the decree relates to estate assessed for payment of revenue to the government, the decree shall be declared rights in the several parties interested in the property, but shall direct rights of the several parties interested of the product, but shall direct such partition or separation to be made by the collector or any gazetted subordinate officer of the collector deputed by him in this behalf in accordance with the declaration and with the provisions of section 54. Then subclause 2, my lord, this is our case. If insofar as such decree relates to any other immovable property or to the movable property, the court may if the partition or separation cannot be conveniently made without further inquiry, pass a preliminary decree declaring the rights of the several parties interested to the property and giving such further direction as may be required. Here, my lord, no preliminary decree is passed. The decree passed by the learned trial judge, which is absolutely reasonable, my lord, being, my lord, they have not made the co-owners of the suit patta, my lord, made party. So, my lord, set aside the decree and said, my lord, that since they have purchased, my lord, they need not make parties, my lord. So it does not hit section order 18, Rule 20, my lord. Order 20, Rule 18, subclause 2, my lord. That is something, my lord, we have formulated, my lord, this substantial question of law, my lord. Page 9, my lord, substantial clause, my lord, paragraph number B. Whether the impugned judgment and decree passed by the learned lower appellate court, being ignoring the provisions of law under Order 20, Rule 6, Order 20, Rule 9, Order 20, Rule 18, Order 26, Rule 13, read with Section 54 of the Code of Civil Procedure. Without mentioning about the names and description of the parties to the suit, description of the suit land in the decree passed in the suit, and without declaring the rights of the parties in the suit, including that the appellant, and without passing a preliminary decree for partition of the suit land, are perverse and unsustainable in law. Then, my lord, next.
Okay.
Yes.
So one substantial question will be sufficient. I
My
think.
lord, my lord. B will be sufficient, my lord.
Okay, yes.
It will
What is
be-
your-
Lordship, I am appearing for the NLM and he is under medical observation. He could not appear before his honor to take part in the hearing today, Lordship. Already, my colleague has already informed his honorable court to he is not well. So today the item may be adjourned, Lordship.
No, already one execution proceeding is pending before the
Execution proceeding is
Yes,
pending
my lord,
before
that
the
is the
trial court
difficulty.
and it is fixed on 7th of August, Lordship. And it is fixed for order on 2 petitions. They have filed 2 petitions under section 151 and another section, another petition is under order 26 rule 9 for Amin commission, appointing an Amin commission. And on that petition, the trial court fixed the order dated 7/8/2025. So any date may be fixed after, before 7/8, Lordship.
7/8
7 of August.
for
This item may be
no for
order on both petition 7/8 on the trial court.
in the execution proceeding.
No, my
Yes.
lord, my instruction is that, my lord, the learned trial executing court has passed an order, my lord, directing us to furnish the order of this honorable court, my lord, with regard to the second RSA file.
Definitely, Your Honor, Lordship, Your Honor.
Unless you produce on that day some order, my lord, from this honorable court, the
No,
decree will be.
if the execution proceeding is pending for hearing on the 2 petition filed by you.
It's not hearing, my lord, it's for order. On that day, my lord, order will be passed and execution. My lord, your lordship
Execution
kindly.
not will be-
My lord, execution has partly been done, my lord. Your lordship kindly, decree has partly executed. Your lordship kindly, my lord, see the stay petition we have filed, my lord. We have annexed the photographs that the decree has partly been executed. My lord, my dwelling house is now on stake, my lord. They are all set to demolish my dwelling house. That is the fact of the case, my lord. And they are, my lord, escaping the, my lord, service. They are avoiding the service for long, my lord, and they partly executed the decree, my lord. Your lordship, kindly have a look, my lord. IA number 3964. We have furnished, my lord, the photographs. Your lordship will find, my lord, the stay petition that we have filed. IA number 3964 of 2024. My lord, I have furnished all the orders passed by the learned executing court, my lord. It says, my lord, the decree has been, my lord, executed. It has been partly executed. My boundary wall has been demolished. Partly, my lord. Subsequently, my lord, because we have filed an application for under order 26 rule 9, my lord, and my lord, the demolition of this part, my dwelling house has been stopped, my lord. And because this case has been pending, my lord, for admission, that is why we have informed the learned executing court that RSA is pending. It's for admitted for admission hearing. But earlier there was a delay petition, condonation of delay, and that is why, my lord, they did not receive notice, and in the process it has been delayed. My lord,
Your Honor,
annexure
delay-
goes to show that, my lord, a decree has been partly executed. Now only they will demolish my residential house, my lord. Now law says, my lord, without ascertaining the share of the, my lord, my lord, the decree cannot be executed.
Lordship, opportunity should be given to the respondent, Lordship.
There will be an opportunity, my lord, after this it is admitted, my lord.
Appellant and also heard Mr.
SJ Rajbangshi.
Learned counsel for the respondent. Mr. Rajvanshi, learned counsel for the
Lordship, any date may be fixed before 7/8.
petitioner, no, for the respondent submits that conducting counsel, Mr. N. Alom is suffering from illness and could not appear before the court.
And our
requests for
and
adjournment.
conducting counsel name has been appeared in the leave note, Lordship.
Mr. Sen, learned counsel for the appellant submits that his appeal under section 100 of the Code of Civil Procedure. The petitioner, no, the appellant challenged the judgment and decree passed by the learned civil judge forfeited in title appeal number 11 of 2020. It is to be noted here that by the no, Mr. Sen further submits that by the impugn judgment and decree dated so and so, the learned civil judge forfeited has allowed the title appeal by setting aside the judgment and decree dated 26/6/2020 passed by the learned Munsif number 1 forfeited title suit number 163 of 2014. Further, Mr. Sen submits that the learned first appellate court without considering Order 20, Rule 18 of the Code of Civil Procedure. And without declaring the right of the several parties to the proceeding, to the suit, and without passing a preliminary decree in the suit, has allowed the appeal, and as such, the impugned judgment and decree so passed by the learned first appellate court is perverse and unsustainable in the law, and that substantial question of laws are flowing out of the aforementioned impugned judgment and decree, and the same has been suggested in case number 9 of the petition, and accordingly, 9 of the memo of appeal, and accordingly, Mr. Sen intended to admit the appeal and to issue notice to the respondents and to call for the record. Having heard the submission of Mr. Sen, learned counsel for both the counsel for the appellant, I have carefully gone through the petition, memo of appeal and the grounds mentioned therein, and also gone through the suggested substantial question of law and the impugned judgment and order dated 14/3/2023 and the decree dated 21/3/2023 passed by the learned civil court with the entitled appeal number 11 of 2020. And also the judgment and decree dated 26/6/2020 passed by the learned Munsif number 1 Borpeta entitled suit number 163 of 2014. The second appeal is admitted on the following substantial question of law: whether the impugned judgment and decree passed by the learned first appellate court in title appeal number 11 of 2020 suffers from perversity or non-consideration of the Order 20, Rule 6, Order 20, Rule 6, Rule 9, Rule 18, Rule 26, and no, Rule 18 and Order 26 and Rule 13. They do it Section 54 of the Code of Civil Procedure. Civil Procedure. Civil Procedure. As the suit was filed for declaration of title, partition, and recovery of possession over the supplant, without impleading all the co-sharers of the said supplant. Issue notice to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued since the respondents, all the respondents are represented by you.
Yes, Lordship.
Since all the respondents are represented by the learned counsel, Mr. Rajvanshi, appearing for conducting counsel, Mr. Anala. Recessal call for the record from the learned courts will place the matter after 4 weeks. The IAEO background heard Mr. Big Descent, learned counsel for the applicant, and also heard Mr. Rajvanshi, learned counsel for the respondents. Application under Order 41 Rule 5, 8 Section 151 of the Code of Civil Procedure is prepared by the applicant for interim injunction by restraining the respondent number 1 and 2 in connection with title execution case number 31 of 2023 pending to the Court of Learned Civil Judge Junior Division number 1 Barpeta. It appears that by order dated 18/12/2024, notice has already been issued to the respondents and the respondents accordingly entered evidence. Mr. Sen, learned counsel for the applicant submits that the respondent herein had already instituted one title execution case, being title execution case number 31 of 2023, wherein the decree so passed by the learned first appellate court has partly been executed and the case is fixed on 7th of August 2025 for report, and unless
not for
operation
report,
of the
Lordship.
impugned order is stayed, impugned judgment and decrees are stayed, the dwelling house of the applicant will be demolished, and therefore Mr. Sen contended that the impugned judgment and decree may be stayed till disposal of the regular second appeal prepared by the applicant. But it appears that the RSA, connected RSA has already been admitted for hearing and notice has been issued and the record has already been called for. Considering the submission of Mr. Sen, learned counsel for the appellate, and also considering the given facts and circumstances of the record, this court is of the view that the prima facie case for staying operation of the impugned judgment and decrees is made out, and accordingly, the impugned judgment and decree dated so and so, hospital learned first appellate court stands state till disposal of the arrest.
Not further proceeding of the title execution number so and so may kindly be stayed.
The decree has been, judgment and decree has been stayed.
My lord, your lordship may observe that further proceeding of title execution case number 31 of.
As the judgment and
Because
decree has been stayed,
they may
cannot
interpret, my
proceed
lord,
with the
otherwise, they may
execution.
interpret otherwise, my lord, that's why I'm.
No.
Yes, that is stayed, of course, your lordship is correct.
Yes,
But-
next item.
Yes, I am deeply obliged.
Standing item 46.
I am deeply obliged.
Wait, please, your lordship. It's regarding my lord provincialization of the service of the petitioner, my lord. Earlier round of litigation, my lord, this honorable court, my lord, passed an order. That is, my lord, I have already. That is at page 55, 56, my lord. Page 56, the 11th portion is page 57, my lord. Page 57. Para 7. Para 7, my lord, page 57. In the, has your lordship got it? Page 7, page 57, para 7. In the circumstance, we are director secondary education Assam to call for the records of the Madhya Panduri Higher Secondary School and verify and whether any teacher had been provincialized in the subject of Sanskrit either under Act of 2011 or under the Act of 2017. If after verification of the record is found that no teacher has been provincialized in the school for the subject of Sanskrit, the director passes a reason order after verifying the service particulars and eligibility of petitioner, either provincialized or the refusing the provincialization of service of the petitioner, but by giving a reason order. Thereof, if the director find that the petitioner meet the eligibility criteria, no one had been provincialized in the subject of Sanskrit in the Madhya Panduri Higher Secondary School, appropriate order may be passed provincialize her service if the order has been directed upon the verification of the record after arrival of the conclusion certain disability existence respect of so and so, appropriate order passed by giving a reason thereof. In requirement of done with the so and so. So accordingly, it was disposed of in pursuance to the order, my lord. The impugn order was passed, that is page 59. Speaking order, my lord.
Yes.
59, my lord. Speaking order, he then read and peruse the Honorable High Court order dated 21/9/2021 passed in WPC number 4780/2021 filed by the Kalpana Devi PGT Sanskrit Madhya Panduri Higher Secondary School, Kalana district of Kamrup. Where is the Srimati Kalpana Devi filed a case before the Honorable Court bearing WPC number 4780/2021 on the Honorable Court by passed an order on 21/9/21 directing the Director of Higher Secondary Education Assam to call for a record of the Madhya Panduri Higher Secondary School and verify as to the whether any teacher had been provincialized in the said subjects of Sanskrit either under Act
So
of.
on the other day, you have substantially argued the matter.
My lord, no, my lord, I just come to that. Yes, my lord, that's at that point of time, see, my lord, my learned friend, my lord, giving a judgment before your lordship, that is the only thing decided. In fact, that judgment, my lord, it helped me, my lord, not the government, my lord.
This WPC number 730.
730, my lord.
Yes.
If your lordship go by the WPC number 730.
Yes, paragraph number.
My lord, paragraph number, my lord, your lordship kindly. Yes, para 8. Para 9, my lord. That is the contention of the government, my lord. Para 9.
Yes.
On the other hand, the Khataniya, the Learned Standing Council of the department has submitted that the consideration of the petitioner cannot be done on the basis of the substitute rule 2018, and therefore the reference the higher secondary examination 2000 will not be arise at all. So far as the reference of the higher secondary examination of the year 2017 is concerned, the Learned Council submit that even the examination would not be relevant as an expression last final examination, appropriate or associate provision would be main examined will be held in previous year, which is the case would meaning the higher secondary examination 2016. The lordship kindly the last final examination appears in aforementioned provision would meaning the examination held in previous year. That is their contention. And which could be meaning the higher secondary examination of the year 2016. In this contention of the department that said year 2016, the numbers of the student of the department economics of the schools were less than 10. The Learned Standing Council has specifically referred the paragraph 5 of the affidavit in opposition dated 16/8/2023, relevant part of this extract herein below. Since the Act of 2017 came into force with effect from 5/5/2017, except the provision of section 4 and 8, therefore the last final examination is considered to be the final examination held the year 2016.
In the instant case, admittedly, the subject on question, the economics of the total number of students preparing the final examination held in the year 2016 was 8. And as such, the case of the petitioner could not be considered for provincialization since that does not fulfill the requirement of the minimum 10 student appears in the last examination economics, subject as provincialized section so and so, so and so. Hence, the writ petition is devoid of any merit and liable to be dismissed. Rejoining this the submission, the said Ahmed Learned Counsel for the petitioner has submitted the interpretation of sought to be given by the department would not be reasonable and would be rather a conflict with the plain meaning of the appears in the provision of law. The private contention advanced by the Learned Counsel for the parties have been duly considered. The material placed before the court have been carefully examined. The relevant provision of law has already been extracted above. The controversy of this case is only with regard to the meaning which can be assigned in the expression last final examination. Expression used in last final examination is not qualified by any other provision which may given the department to the content that it is the examination held in the previous year. When the statute is question is plainly worded, there is no scope for giving any other meaning than the which the appears from the plain reading of the statute. Under the principle of the interpretation of statute, it is the plain meaning of which the required to be taken into consideration, unless the plain reading does not make any reasonable construction. In the instant case, there is no dispute that regarding the fact that the examination was higher secondary examination in the year 2017 was held between February 2016 and 2017. An expression used in statute is regarding the appear to be at least 10 students. The department has not disputed the data produced in case of regarding the number of students who have been projected in 2013. Under those circumstances, this court is the opinion that denial of the benefit provision of the section of given in the incorrect meaning to the provision of the law is not at all justified. Accordingly, this court is the opinion that the case of the reference is made out. Consequently, the petition is allowed by the holding that petitioner had fulfilled the requirement of section 315 Act of 2017. Therefore, the entitlement and regulation of service, the authority, namely Director of the Secondary Education, is accordingly directed to pass a necessary order in this regard expeditiously and within a period of 60 days, limit of 60 days from today. Since the petition has been held to have fulfilled the requirement for provincialization of service, in effect of such provincial given for the date of when the similar situation person was provincialized. So your lordship kindly see in this case, my lord, they say that it should be 2016. Last year means the previous year. That is their, my lord, contention, my lord. But your lordship kindly see, although it is, my lord, not giving any pronouncement or any my lord finding, but my lord, according to my lord, plain meaning of the my lord act, they have to go, my lord. Your lordship, last year means last year. Your lordship kindly see their contention was rejected by this honorable court, my lord, by this honorable. And accordingly, the petition was allowed. In that case, my lord, in 2017, they say that it should be 2016 because it was that act was, my lord, of 2017. It was amended in 2018, my lord. In 2018, it was amended that section 3 also amended, my lord. So, my lord, in that case, here in this case, my lord, if your lordship, my lord, if they go by the contention of the petitioner by respondent, my lord, then also, my lord, in 2018, my lord, more than 10 students in my case also, my lord. But as your lordship kindly see the plain meaning of the section 3(7), subclause 7, the last years. As per last year, my lord, that means, my lord, that when you my contention, my lord, when you consider just before that, my lord, last year means, my lord, you are, if it is, my lord, is it, my lord, that is 2016, even in the amendment act, my lord, it should have mentioned that it will be last year means 2016, but that is not there. So your lordship kindly see that amended in 2018, my lord. While 2018, it is also amended in the amendment. That section was amended, my lord. The section 3 also amended, my lord. 3(6), 3(7) is also amended. It is also, my lord, last year. And that amended, my lord, amended rule was amended, my lord. It was notified in, my lord, 9th of May 2018. And the exam, the 2018 exam was held in February, my lord. So last mean, my lord, 2018, if your lordship go by their contention, if they are good, their argument, even then also I am eligible, my lord.
18 and 12.
In 18, my lord, 12 student appeared, my lord. And not only that, my lord, your lordship asked me to file additional affidavit. I have been giving every years, my lord. Every years, my lord. Up to 2024, my lord, I have given, my lord.
25.
And
25, page 78.
page 78, my lord, I have given, my lord. And my lord, if your lordship go by the, my lord, intention of the legislation, my lord. In earlier act, my lord, this act was repealed by my lord, 2011 act, my lord. In 2011 act, my lord, there is a, my lord, provision, my lord. Because this act, present act was, my lord, 2017, my lord, 2000 amended in 2018. It was replaced the earlier act 2011, my lord. My lord, then that book, my lord, your lordship will find that 2011 act 647, page number 647, my lord.
No, in this book.
Yes, yes.
Oh, yes.
Manual.
Yes, in that,
Page
my
number?
lord, it is,
Yes.
yes, 647, my lord. Assam Venture Educational Institution Provincialization of Service Act 2011.
Yes.
This, that is, my lord, in note, my lord, your lordship will find that is, my lord, that act is been replaced by, my lord, that's 2017 act, my lord. Your lordship kindly, section 3, page 651.
650?
651, page.
Yes.
Eligibility criteria for selection of the educational institution for provincialization of service of its employees. Subject to the provision of the Act Article 13 of the Constitution of India, for the following categories of venture educational institutions shall be eligible for being the consideration for provincial of service and its employer. Subsection 3, your lordship kindly see. 3.3, my lord. In case of high school, my lord, next page, my lord.
Yes.
In case of high school or higher secondary school or junior college or degree college, the concerned educational institution must have consistent good academic performance, which will mean that at least 30% of the candidate appearing in the final examination must have passed in any 3 examinations held since 1/1/2006. So in that, earlier intention was that, my lord, in any three examination from 2006 to 2011. But nowhere in the act, my lord, this is defined last year, my lord. So my submission before your lordship kindly see if the intention of the, my lord, in legislature is that, my lord, that if it is only the year 2016, then specifically mentioned 2016, my lord. But while amending in 2018 also, they have not, my lord, stated that it is be 2016. It is, my lord, 2000 last year. They have mentioned the last exam. So that means, my lord, but if your lordship giving the rigid only 1 year, then, my lord, there is no value of that section, my lord. And in fact, my lord, in by their judgment was just shown by my lord, and my lord, in that case, my lord, their contention was rejected by this court, my lord. They say that it should be 2016. Last year mean 2016. Okay. That is my submission, madam.
Yes, madam. What is your submission?
My lord, that is the amendment will probably your lordship.
It is with you.
2018, madam. That is for your lordship, madam. Itu tohon beya hoise dekho. 1/9/2016 to sana.
17.
The 17 will be 17 of PA2.
Yes.
Lordship, in our affidavit, we have taken the stand that the base year from which it will be, the year that will be considered is from the date when the act had come into force, your lordship. The act had come into force on 11th of April 2017, your lordship. So the last examination will be counted from the year 2016. That is the stand that we had taken in our affidavit, Your Lordship. Lordship, on the last occasion, I had placed the provision by which the act had come into force, Your Lordship. And it shall come into force on such date as the state government may by notification in the official gazette appoint, and different dates may be appointed for different provisions of the act or for different category of educational institutions, Your Lordship. And the act had come into force on the 11th, Your Lordship. So the base year that has to be taken is from 2016, Your Lordship. From 2017, the last examination would be 2016, Your Lordship. And accordingly, I had placed, Your Lordship, section 3(7), Your Lordship. Section 3(7), Your Lordship. 3, subsection 7, Your Lordship.
Yes.
Okay, for provincialization of services of one teacher or tutor, as the case may be, in each subject, including the core subjects in case of venture high school or venture high madrasa or venture higher secondary school or venture senior secondary school, at least 10 students must have appeared in the last examination in that particular subject from the institution. Further, for provincialization of services of maximum so and so, Your Lordship. And Lordship will also come to section 4, Your Lordship. Section 4. Subclause, Lordship, 4. 115 page. 115, Your Lordship.
Yes.
Lordship. 4, Your Lordship. In case of teachers and or tutors of the schools for special subjects like Sanskrit, Arabic, Hindi, craft teacher, music teacher, and other classical teachers, the number of students appeared in the concerned final examinations like HSLC and HS conducted by the SEBA or the ASHEC, as the case may be, shall not be less than 10 students in each class per year during the last 3 years, Your Lordship. This is regarding, Lordship, provincialization of services of teachers and tutors, Your Lordship. So there has to be at least 10 numbers of students or more than 10, Your Lordship, during the last 3 years. And Your Lordship, the case that I had placed, Your Lordship, Jasimuddin's case, Your Lordship, there the school was provincialized in the year 2021, Your Lordship. And the last examination that the finding that they had reached is that the last year will be counted from 2017, Your Lordship, and not from 2016. So the base year was taken from the year, Your Lordship, when the act had come into force. Lordship, as I can understand, is that provincialization of a school will not be a continuous process, Your Lordship. It will be, the school will be provincialized once along with the teachers, Your Lordship. So the year that can be considered will be the year from the day on which the act had come into force, Your Lordship.
So when the school was provincialized?
School was provincialized under the 2011 Act, Your Lordship. It was provincialized in the year 2013. However, due to the direction of the court, Your Lordship, we were asked to consider if he can be provincialized under the 2017 Act. And after, Your Lordship, after considering a report from the IS and
That is there in the annexure 17 of the petition?
Yes, Your
Number
Lordship.
59.
Yes, Your Lordship.
here it has already been stated that the district level scrutiny committee had not recommended his name, your lordship, because his enrollment in Sanskrit subject during 2016 in HSLC examination was only 6. And your lordship, under the Act, Provincialization Act 2017, a procedure has to be followed. Because it has to, the district scrutiny committee has to recommend it to the state scrutiny committee, your lordship. That is the procedure. And if the district level committee has not recommended, your lordship, it will not be possible for us to recommend to provincialize his service.
May not be, but why you are there?
Lordship. Lordship.
You cannot act like a post office.
Lordship.
You have to examine the recommendation of the district level committee, whether it is in accordance with law or not in accordance with law.
Lordship, it is in the speaking order itself, it has been stated, your lordship.
Merely because a district level committee has rejected their pair, you cannot reject it.
No, it is not based on only on that report, your lordship. The report had come from the inspector of schools also. After considering the report of the inspector.
There is no dispute that in the year 2016, the number of enrollment was only 6.
Yes, your lordship.
He is also not disputing.
Yes, your lordship.
But regarding that.
Regarding the
yes,
expression, the
last year.
Last
year means which year? Only 2016?
According to us, lordship, it will be from the day the act had come into force. It had come into force on 2017. And so the last examination will be calculated from 2016, your lordship. Because the otherwise there will be different dates, your lordship, for different category of persons, your lordship. And the very purpose
so, if we take if we accept your submission,
lordship,
that the number of enrollment has to be taken into account only in the year 2016.
Yes, your lordship.
Then in subsequent cases, no service of the teachers can be provincialized.
Lordship, that is the issue, your lordship, because
is it the intention of the legislature?
Lordship, because they will be recruited, your lordship. If recruited under the lordship provincial under this Act 2018 Act, your lordship. Provincialization under 2018. Because once if the teachers are drop teachers, your lordship, their services will they will be considered. If we find that they do not fulfill the provisions of this act, your lordship, so they will their services cannot be provincialized. Okay. Because we have another act, your lordship.
Who said?
Lordship, I'll just come to it. This is the Assam Secondary Education Provincialized Schools Services Rules 2018, your lordship. Page 18, 1-8.
Yes.
18, your lordship. This is lordship will come to rule 7 and 8, page 28, your lordship.
Yes.
So they will be recruited under 7 and 8, your lordship. Recruitment will be done under 7 and 8, your lordship. Recruitment of teachers. This is regarding the undergraduate, your lordship, 7, rule 7, and rule 8 is recruitment to the post of graduate teacher. It will be through advertisement, your lord.
But this court has directed earlier to consider his case under the Act of 2017.
17, your lordship. That is why we had considered, your lordship, and we had taken 2017 as the base year, your lordship. And last examination
2016
Okay.
was taken, you know.
All right. Heard Mr. T.J. Monto.
One thing I have clarified, madam, my in annexure 12 page 48, my name is forwarded by the inspector of the school, and also in there is a mention that my scrutiny committee also might have reflected that I am the senior most teacher.
Page number?
Page number 48, madam. Letter dated 19 February 2021. By the inspector of school to the director, madam. Everything reflected in my case is there, madam.
Seniority should not be the only criteria, your lordship, for provincialization.
No, that is the district level scrutiny committee, my lord, that is now reflected, madam.
Okay.
That is it.
Heard Mr. T.J. Monto, learned senior counsel assisted by E. Procedural, learning counsel to the petitioner, and Ms. D. Musahari, learned standing counsel for the respondent in secondary education department. Argument concluded. Judgment reserved.
Deeply.
Obliged.
Timing item 27.
Anand, your junior here.
Yes, your lordship. what
And
is-
on being asked, she submits that she has no objection in the event of condoning delay
No,
of
what-
800 and
No, actually, what has happened in this matter, your lordship, the petitioners, the appellants have served us the copy of the RSA. But they did not serve us, in fact, the copies of the other IAs. Therefore, we were actually, I was in the dark whether that IA was with regard to condonation of income. Condonation of income. I thought that was with regard to the substitution, because the substitution part has been done and notices have been issued. Today I have come to
no,
know.
Mr. Mannan, you see, RSA is yet to be admitted.
Yes, exactly.
Then where is the question of substitution?
No, in fact, there was a, your lordship, direction by this honorable court. When the, yes, there was a direction for substitution of respondent 2. That is why, your lordship, because only the appeal memo was given to me. That's why I was in the dark whether that was. So I thought the substitution is there. Then respondent 2 has been substituted as a 2A, 1 and 2, 2. And in last order also, your lordship, is there in the main case. But subsequently today, your lordship, I've come to know that there's a delay, and that's why the copy of the delay petition has not been served. Yeah, ma'am. We have actually, on the last occasion, I requested, but I have not provided.
I will, sir. I will, sir.
Heard Ms. Esroy, learned counsel for the applicant, and Mr. Mannan, learned counsel for the respondent. Mr. Mannan submits that copy of this interlocutory application has not been furnished to him. Mr. Roy undertakes to furnish a copy of the same to Mr. Mannan during the course of the day. Accordingly, it is provided that this is a less than after 1 week.
Lodge. Much obliged. Okay, so DD.
Item 34.
May I please your lordship?
Yes.
Lordship, the I number 1285 is for condemnation of delay of 212 days.
I number 1258.
58.
Mr. Sharma, you have filed objection here?
Yes, your lordship. We
When?
have- First of all, your lordship, there is a calculation mistakes. It's in 383 days.
Pardon?
There is a mistake on calculation side. And
It's a calculation made by the registry.
no, your lordship. It is. The judgment was passed on 21/3/2024. Medical document attached from 15/1/2025.
As per registry, there is delay of 212 days.
12 days.
You have any doubt about this calculation?
Your lordship may take other objections then. I cannot make on comment on that, your lordship.
Okay. So what is the ground, madam?
Your Lordship, the appellant is appellant number 1 is a 87 years old lady. She has been suffering from various age-old related ailments, and they are also financially not very stable. So, my lord, there has been a delay due to financial instability of the family.
The applicant is of 87
Seven, eight-
years old lady.
Yes, my lord.
And she is she is not financially sound.
Yes, my lord.
Any other ground?
My lord, that's it. My lord, the family is not financially stable. So there has been a delay in consulting and in preferring the appeal.
Yes, Mr. Sharma, what is your objection?
Your Lordship, paragraph 3 of their petition. That is, they themselves have admitted that after the appeal was dismissed, there arose some miscommunication. They have the knowledge.
So what wrong with this?
Your Lordship, they have the knowledge
Yes,
that
sir.
after their appeal was dismissed, there was a miscommunication. Not prior to the dismissal of the appeal. That means they have the knowledge of the judgment. Thereafter, there was some miscommunication.
No, after dismissal, there arose some miscommunication. That means after dismissal of the appeal, it was not communicated to them.
And
Yes,
Your
my
Lordship may
That
kindly
can
come.
be that can be assumed from perusal of this paragraph.
And Your Lordship, then the judgment was passed on 21/3/2024. They have attached the medical document from 15/1/2025. That is the gray area, Your Lordship. And Your Lordship may kindly peruse the medical document at page number 11.
Yes.
And that is only the reports. One set of document starts from 15/1/2025 and thereafter 1/3/2024 at page number 16.
So these documents goes to show that she was suffering from some ailments. Is there any doubt?
Yes, my lord.
No, Lordship, doubt is not there, but the judgment was passed on 2024 and they have come up with the documents on 1/1/2025.
Your lordship, there are documents of.
There is no day-to-day explanation of delay.
Is it a requirement of law that each day and each hours, each minutes has to
Your
be
Lordship, there is a
explained?
judgment that day-to-day must be explained in the petition.
Yes, sir.
They have straightway come to the point that she is an old lady with a diabetic. Nowadays, everyone is in diabetic, Your Lordship. And this is in second appeal.
We will see. Let us condone the delay. Third, Miss, your good
Jay
name.
Sharma, Jay Sharma.
Learned counsel for the applicant and also heard Mr. Sharma, learned counsel for the respondent. This application under section 5 of the limitation act is preferred by the applicant for condonation of under section 5 of the limitation act, read with order 41 rule 3 within bracket capital A, read with section 151 of the code of civil procedure. For condonation of delay of 212 days in filing regular second appeal against the judgment and decree dated 21-3-2024 passed by the learned civil judge Hailakandi. Ms. Sharma, learned counsel for the applicant, submits that the applicant is old lady of 87 years. No, is a lady of 87 years old, and she has been suffering from old age diseases, and besides, she is not financially sound. And also, there was some miscommunication between the earlier set of counsel after dismissal of the appeal, and that the delay is not intentional and rather the same is circumstantial, and therefore she has contended to allow this application. For contra, Mr. Sharma, learned counsel for the respondent, submits that the respondent have filed their objection in condoning the delay, as the delay has not been properly explained, and the medical documents are also of 2005, no, 2025, whereas the judgment was passed on 23rd. When it was passed?
21-3-2024.
21-3-2024. 21-3-2024. And as such, Mr. Sharma submits that the delay has not been sufficiently explained, and therefore it is contended to dismiss the application. But having heard the submission of learned counsel for both the parties, I carefully with the petition and the documents placed in record. It appears that the applicant has enclosed with the application some medical documents as Annexer 1, series at page number 11 to 17. And perusal of the said documents goes to show that the applicant is suffering from some ailments. Further, in the application, it is stated that the applicant is not financially sound, and therefore there was delay in filing the connected regular second appeal. For taking note of the submission of learned counsel for both the parties, and also considering the statement and averment made in the application and the documents enclosed with the application, this court is of the view that the delay of 212 days have sufficiently been explained, and accordingly this court is inclined to condone the delay. Inclined to allow this application by condoning the delay of 212 days. In terms of this high instance clause, high instance disposal. In view of the order passed in the I number so and so, they will proceed to register the regular second appeal and list the same before the court as soon as practical.
25.
May I please, my lord? My lord, as per office note dated 21/7/2025, neither AD card nor unserved notice returned back, my lord.
You are appearing?
I have 4, 2, 3, and 5, my lord.
2, 3, and 5.
My lord. 4 has died, my lord. 4 has been substituted by the my lord. Substitution petition has been filed.
But they belong to the same family. If I take the instruction, my friend take the instruction, my lord. They belong to the same family, my lord. Here, my lord, one of the respondent died, my lord. So this is application.
Respondent number 4 has died, my lord.
Heard Mr. Gupta, learned counsel for the applicant, and also heard Mr.
S. Hazarika, my lord.
S. Hazarika, learned counsel for the respondent number
2, 3, and 5, my lord.
2, 3, and 5. Office note dated 21/7/2025 indicates that neither AD card nor unserved notice in respect of respondent number 41A and 41B are received by the section till date. Do you want to take test step or will
No,
everything?
it was only sent on 11/6, my lord. So let it may come up after 2 weeks, my lord. In the meantime.
No, in meantime, I'll take instruction, my lord. These other respondents, my lord, are the sons of the respondent number 1, my lord, who died, my lord. Till that we have not received the instruction for appearing for the legal.
You obtain instruction and let this court know
Yes, my lord.
next day.
Keep it after 2 weeks, my lord, will take.
List the matter after 2 weeks, everything service report upon respondent number 41A, 1B.
Okay. 36.
Your lordship, in this case, as per office note dated 21/7, lordship, neither edit cards nor unserved notice have been received in respect of respondent number 1 to 4. So await service report, lordship, in IA, lordship.
Pardon is also really learned counsel for the office note dated 21/7/2025 indicates that neither a card or unserved notice is taken by the LST. Respect of respondent number 1 to 4. List the matter after 2 weeks, awaiting service report upon the respondent.
Item 37, lordship, IA civil number 2221/2025 is for impleading some appellants, lordship. Appellants number 6 to 9. In the decree of the first appellate court, your lordship will find from the memo of appeal, lordship. Memo of appeal, page 62, lordship, the name of.
Who is for the other side?
Other side, Mr. GP Bhomik, one Bhomik, lordship. Guru Pada Bhomik. Your lordship, we are for the appellants and some of the appellants' name were remained as lordship not included in while preparation of the regular second appeal, lordship.
That's all right, but whether we'll not hear the other side on this application?
For appellants, your lordship in its own discretionary power, lordship can kindly see page 62. The name of the persons are already in the decree. Memo of appeal, page 62, lordship. Or your lordship may fix it on Monday, lordship.
Next Monday.
Lordship.
Can you inform the other side?
Yes, lordship, I have his number, lordship.
Or Miss or superior learned counsel for the applicant. This application under order 1 rule 10 open bracket 2 read section 151 of the Code of Civil Procedure is required for impleement of appellant number 6 to 9 in the connected regular second appeal number 63 of 6. List this application on Monday for consideration. Wednesday.
Lordship may direct registry that in the meantime we have filed substitution, abatement and condonation application also for appellant number 2, lordship. That may also be listed along with this application, lordship. There are other 3 applications are pending for appellant number 2, lordship. So after passing order by this court, we have to file amended cost title, lordship. It will be better if we, after consideration of all the 4
in this application, we will not pass any such direction.
No,
Let
in
the rest list.
RSA, your lordship may direct the registry to list the other 3 IS which we have already filed on 24/6/2025 for substitution of appellant number 2, lordship. In the RSA, lordship. Appellant number 2 already died, lordship, so we have filed.
No, is there any order in this regard in the RSA?
No, lordship. We have filed, we have taken information that appellant number 2 died. So we have filed on 24/6/2025. Or Lordship will pursue the matter, Lordship. Obliged, Lordship.
But also this connected second appeal has already been admitted and my learned senior colleague has entered appearance, Lordship. Today we have filed is listed before your Lordship for consideration of IA civil number 2225, Lordship. At the time of filing of the connected appeal, this IO was not filed, Lordship, and the title execution case number 8 of 2023 is proceeding, Lordship, before the trial court. So in this petition, we are coming before your Lordship with a limited prayer. As the connected second appeal has already been admitted, the further proceeding in the title execution case may be stayed, Lordship.
Lord, in the already there is a status quo order passed by your lordships.
When?
My lord, in IA 1907 of 2025.
IA number?
1907.
I have annexed the order, Lordship, page 13.
And so, my lord, this petition is not, my lord, required.
But we have presented.
Only here is the question is the, my lord, his first appeal was dismissed on the ground of delay. Against that order, he has filed his second appeal. Now, if that order is correct or incorrect, that is to be decided here in this second. If it is not correct, then it will be remanded back to the, my lord, first appellate court. This is the issue. So, my lord, may I pray in this note that this matter may be heard in the next upper take.
Yes, yes.
And till then, my lord, the status quo are already there. They will not be, my lord, affected. And so my instruction is concerned, execution case has been stayed because of that status quo. So a date may be fixed, it may be finally hard. Only on the ground of delay, my lord, was dismissed.
And my instruction is that, Lordship, the case is next fixed on 18th of August, Lordship. We have presented on the last date fixed, Lordship. We presented both disorder for the learned executing court. The learned executing was of the view that since there is no specific direction to stay the proceeding, so the court did not stay the proceeding, Lordship. The only direction the parties are to maintain status quo. That is the difficulty the learned executing court was finding, Lordship.
But before August 18, my lord, it may be fixed. No problem.
No, but, there is no difficulty on that, Lordship. But at least this
Till then, my lord, the
execution may be stayed, Lordship. This application may be considered today, Lordship, as the learned senior colleague has entered appearance. But I have no difficulty. I have no difficulty on hearing the status quo order, Lordship. We have tried to convince the learned executing court. The learned executing court was of the view that there is a direction direct the parties to maintain status quo. There is no direction to the court. This is the version of the learned executing court, Lordship. That's why we are compelled to file this application, Lordship, order 41 rule 5, Lordship. Under specific.
We will maintain a status quo.
Parties. That's why that is the exact version of the learned executing court.
Proceed with the execution, please.
Oh, all right.
The final only for delay condition, my lord.
Heard Mr. Didas, learned counsel for the applicant, and Mr. Enoch, learned counsel for the respondent. And I equal to 5. This application under order 41 rule 5 of the rule 5. Read with section 151 of the Code of Civil Procedure is referred by the applicant for staying the proceeding of title execution case number 8 of 2023. Pending before the Court of Learned Civil Judge Junior Division number 1 Barpeta till disposal of RSN number 95 of the. As agreed by learned advocates of both the parties, list this IA along with RSN number 95 of 2025 on
12 August.
12 August for hearing.
12 August, I have
And
some
final consideration of the RSN number 95 of 2020.
12 August, I have some difficulty. One day prior or one day later? Lordship.
39 August.
And appears for the applicant on call is the matter after 1 week.
40. Maybe your lordship. But this I is for condemnation of delay from for the first time lordship.
How many days?
1,144 days, Lordship.
Heard Mr. Sharma, learned counsel for the applicant. This application under section 5 of the Limitation Act is prepared by the applicant for condonation of delay of 1,144 days in preparing appeal against the judgment and award dated 12/2021 passed by the learned member, Motor Accident Claim Tribunal, Golgota, in MSC case number 321 of 2017. Let notice be issued to the respondent returnable in for which step be taken by research force with AD and also by usual process within a week from today. List after 4 weeks.
Apply, Lordship.
41.
May I please, Lordship? Lordship, there is an IF for containing a delay of 162 days, Lordship.
Heard, Mr.
Ega Koti, Lordship.
Learned counsel for the applicant. This application under section 5 of the Limitation Act. Read section 173 of the MT Act. Is prepared by the applicant for condonation of delay of 162 days in preparing the connected appeal against the judgment and award dated 5/7/2024 passed by the learned member MSCP Pomaino in MSC case number 87 of 2006. Let notice be issued to the respondents returnable in for weeks that be taken by research force with AD and also by legal process within a week from today. List the matter after 4 weeks.
42.
Delay of 72 days, my lord, in filing the first appeal, my lord, against the title suit number.
Heard, Mr. I alone learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act is prepared by the applicant for condonation of delay of 72 days in preparing title suit number. In preparing
65 of 2014, my lord.
In preparing first appeal against order. Dated 38/8/2024 passed in PS number 65 of 2014 by the learned civil judge senior division Kasar Silsop. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered force with AD and also by legal process within a week today. List after 4 weeks.
Obliged, please.
Item 48.
Maybe lordship. Lordship is a regular first appeal.
It is in the order column today.
Lordship.
What is the matter?
Lordship is a regular first appeal against a decree. So lordship, it is a suit for 2005 for compensation. And accordingly, suit was decreed. It's a title suit. It was for decree for compensation and compensation was given. So the right of appeal is there, lordship. So I am ready to pay the deposit, the security amount 30% as your lordship, please, against the decretal amount.
What is the quantum?
What's lordship? 24 lakhs. Two amounts, 24 lakhs for compensation and 24 lakhs 53,900 for compensation, 24 lakhs 53,900 as principal amount. That means in total your lordship 49 lakhs 7,800.
You want to deposit
30%.
any objection?
50%. Other cases also 50% is
The other cases 30% has been given.
In the other case, similar type of case, 30% was paid, but that case was different. My case is that for last 15 years, I have been residing in a rented place. My house was demolished because of their negligence.
So at least 30% only, another case 30%.
Because I have to arrange for some other accommodation. For last 15 years, I could not do that. So lordship will consider that.
If 50% is paid, so I can arrange for some other alternative accommodation. And interest loss penalty, interest amount will be more than principal amount. It is for their benefit that they should pay 50% of the.
So this appeal is yet to be admitted.
Yet to be admitted.
Yeah, yet to be.
Then one stay petition is there.
Lordship.
Now lawsuit will admit the appeal, and in the IA lawsuit will pass it on.
Third, Mr. R.K. Bhuya, learned counsel for the appellant, and Mr. Khatunier, learned counsel for the respondent. This appeal under under section 96, read with order 41, rule 1 of the Code of Civil Procedure. The appellant has challenged the correctness or otherwise of the judgment and decree dated 12/12/2024, passed by the learned civil judge, senior division number 1, Kamrup M. Guwahati, in title suit number 469 of 2012. Is to be noted here that by impugn judgment and decree dated so the learned trial court has decreed the suit
Operative portion lordship at page 87.
87 of IA, no?
Lordship. No. RS. FA, RFA.
For recovery of 24,53,900 jointly and severely from the defendants with interest at the rate of 6% per annum for the date of filing of the suit with realization, and also a decree of compensation of rupees 24,53,900 jointly and severely from the defendant along with 6% from the date of filing of the suit till realization with cost. There is the memo of appeal and the grounds mentioned therein. And also there is the interim judgment and decree dated 12/12/2024, passed by the learned civil judge, senior division number 1, entitled suit number 469 of 2012. Admit, issue notice to the respondent. Returnable in 4 weeks. However, no formal notice is required to be. You are representing all the respondents.
Only one respondent, lordship.
Full respondent.
Okay. Since the sole respondent is represented by Mr. Khatunier, learned counsel, no formal notice is required to be issued. However, extra requisite copy of the memo of appeal be furnished to Mr. Khatunier during the course of the day. Rest is call for the record from the learned court below. This is the matter of 4 weeks. IA number 1902 of 2025. Third, Mr. Bhuya, learned counsel for the applicant, and Mr. Khatunier for the respondent. This application is prepared by the applicant under Order 41, Rule 5 of the Code of Civil Procedure for staying impugn judgment and decree dated 12/12/2024, passed by the learned civil judge, senior division number 1, Kamrup M. Guwahati, entitled suit number 469 of 2012. Whereby the suit has been decreed in favor of the respondent hearing. Mr. Bhuya, learned counsel for the applicant, submits that the connected regular first appeal has already been issued or already been admitted by this court, and notice has been issued and record has already been called for. And as such, there is a requirement for staying the impugn judgment and decree till disposal of the RFA. And he is ready to pay, ready to deposit 30% of the decretal amount before the registry of this court as security. Mr. Khatunier, learned counsel for the respondent, submits that the security amount may be increased to 50%. No, the petitioner, no, the applicant may be directed to deposit 50% of the decretal amount since the respondent has been residing in a rented premises. Taking note of the submission of learned counsel for both the parties. This interlocutory application stands allowed. The impugned judgment and decree dated 12/12/2024 passed by the learned civil judge senior division number 1 Kamrup M Guwahati in title suit number 469 of 2012 state till disposal of the regular first appeal, subject however to depositing of 50% of the typical amount.
50% not if he is a patient
is
of the
better for him.
transplantation.
Because in every
He is-
day interest is accruing.
No, he is a key, not him, so far the API is concerned, recently kidney has been transplanted. So that is where 30% at least.
Ultimately, you have to pay the amount.
Lordship,
in the
Lordship,
event
even then,
dismissal of the
it's just
appeal.
a relaxation, Lordship, 30%. If you in another case,
Let us look
30% has
at
been given.
30%.
Except on deposit, I may be allowed to withdraw the amount.
Mr. Khatonia submits that on being the security amount being deposited before the registry of this court, the respondent may be allowed to withdraw the same. That is accordingly allowed. You have filed caveat.
Lordship, this is filed.
Yes, yes.
Caveat or
Caveat.
caveat stands discharged.
49.
In this matter, my lord, as per the earlier order, my lord, we were directed to file written objection, my lord, against the delay condonation, my lord. We have filed the written objection, my lord, and it is also on record, my lord.
But kindly take up the IA, our IA, my lord, we have prayed for stay of the execution. That IA is 2137 of 25. A conditional order was passed by the honorable court, directing us to deposit an amount of rupees 3 lakhs and to submit the proof of deposit of the amount. I have given the copy, my lord. Kindly take up 2137 of 25. The last order dated 10/7 now. Para 6, my lord. As a condition of the stay of the execution, the applicants are directed to deposit a sum of rupees 3 lakhs before the learned executing court in connection with money execution case number 1 of 23 within 21/7/2025 and produce.
That's all right, but the delay is yet to be controlled.
Delay is yet to be controlled, my lord. IA 648, Lordship may kindly take up.
No, you tell me, without condoning the delay,
Lordship.
can this IA be entertained?
Well, the IA Lordship has on the last occasion, Lordship has considered that IA to be an IA under 151 of CPC, Lord. And considering the kindly take up the order, para two of the order.
That's all right,
Last-
but can it be without admitting the appeal?
Well, even in a case, even in a given
Supposing
case,
I am not condoning the delay,
Lordship,
what would be the fate of the appeal?
and ultimately
Appeal will also be dismissed.
ultimately it goes, Lord. Ultimately it goes.
Then what will be the effect of this order?
Well, it will be ultimately merged with that.
Then
But kindly see, my lord, in a given case, considering the matter, my lord, even on that day, my lord, I have shown it is on record, my lord. I can show before the honorable court. My lord, here is a case, my lord, that the vehicle of the petitioner along with the stolen good was seized by police, and the vehicle got damaged, and he filed a suit for recovery of the compensation. Ultimately, on the basis of the evidence.
okay, you tell me what is the ground of delay?
Lordship. Delay, my lord, Lordship may kindly take up IA 648 of 25. But we have explained the delay in paragraph 3, my lord. Para 3, my lord, page 4. Lord, Roman 1, my lord, there is delay of 613 days and the aforesaid delay occurred due to the following reasons. Number one, the judgment and decree was passed by learned civil judge Baksa in Manisut number so and so on 3 of 2022 on 17/12/22. The applicants were represented by the learned government pleader before the learned court below, and the learned government pleader informed about the judgment and decree dated 17/12/21 to the applicant number 3 in the first week of February. The applicants were not aware about the said judgment and decree dated 17/12/22 before receipt of the aforesaid information from the learned government pleader. After having knowledge of the judgment and decree dated 17/12/22, the applicant number 3 in a third week of February 2023 deputed an official to meet the concerned government pleader Baksa to get the copy of the judgment and decree and of the said money suit. In the meantime, notice issued in the money execution case number 1 of 2023 has been received by the applicant on 18/3/2023. Thereafter, in the last part of March 2023, the copy of the judgment and decree dated 17/12/23 of the said money suit was made available to the office of the applicant number 3. However, in absence of the records of the money suit, such as the records, the applicant number 3 requested the learned government pleader to provide all the relevant documents for taking further action in the matter. Thereafter, the learned government pleader obtained the certified copies of the relevant documents of the money suit number so and so on 29/8/2023 from the office of the learned court of civil judge Baksa and handed over the same to the applicant on 7/9/2023. And subsequently, my lord, steps have been taken. And after going through the judgment and decree along with the other records of the suit, the applicant number 3 again took up the matter with the learned government pleader for taking further necessary action. On 3rd week of September 23, the applicant number 3 is done.
Okay,
So,
yes,
that-
Mr. Das, what is your objection?
My only submission is that, my lord, can this matter be taken up on a different date, my lord? I have to go to the record, my lord, from the accommodation, my lord. Any date, my lord, this week or next week.
No, you have already filed objection.
Yes, I filed objection, my lord. I just
Then-
need to place some judgments also, my lord, on this, my lord. Any date, my lord.
Judgments on there is delay of 613
Yes, that's why,
days.
that's why, my lord.
But I am placing reliance on the decision, Mala. This decision is my respectful submission is not while considering the petition, Mala, Lordship may also consider the merit of the case, Mala. The merit of the case may not be ignored at all while considering the delay petition, Mala. And the approach has to be a pragmatic approach, and that is the.
So the execution case has been filed.
Execution has been filed, and my lord.
And what is this that execution case is pending?
Steps have been taken, my lord. As per my instructions, steps have been taken.
Attachment warrant of attachment has been issued, and at that
Next date is takes on.
Now Lordship has stayed the petition. It is on 19/8. Next is 19/8. It is stayed because of Lordship has passed the order in our IA on 10/7. Now, considering deposit of the amount in the last order, the execution has been proceeding has been suspended till 19th of August. Well, the vehicle, the value of the vehicle, the witness here, if Lordship kindly takes up the.
No, let us do one thing, Sanat. He press for little accommodation.
Lordship.
Let it be fixed on next week.
Before 19/8, my lord, any date.
Lordship.
8th of August.
Man.
On the pair being made by Mr. S. Das, learned counsel for the respondent, opposite party, having not been objected by Mr. Dinat, learned senior government advocate, the matter stands adjourned to be listed on 8th of August.
Well, the interim order is still to be.
Interim order.
It was a conditional order. I have submitted the proof of deposit law.
Since in IAC Bill 2137 of 2025, you take down Mr. Dana, learned senior government advocate for the applicant that produced the proof of deposit of rupees
3 lakhs, Lord.
3 lakhs before the learned executing court
Lord.
on 19/7/2025. And in view of above, the interim protection, the interim the interim order granted, interim stay granted by this court by the order dated 10/7/2025 shall continue.
Lord. I'm all right. 50.
Mr. But you, this decision you keep it with you.
Lordship.
You produce it on that day,
Yes.
otherwise it may be misplaced here.
Lordship. I'll produce, my lord.
My lord, this matter will take time. It may be taken Friday or Monday.
Okay. Wednesday? Next Wednesday?
Okay.
As agreed by learned advocates of both the parties, recess the matter on Wednesday.
Item 51. Obliged.
Here, my lord, my I is for stay of the impugned judgment. Lord, my RSA is otherwise, my lord, the lordship has admitted the RSA. And if lordship kindly comes to page number 71, my lord.
RSA has already been admitted.
It is admitted, question of law has been framed. Page number 71. There are developments, my lord, in the meantime.
Whether the other side entered appearance?
No, no, we have taken steps.
No, in the RSA.
No, I have checked the record. The notice was issued, AD card has been sent, but it was returned answer. It was returned answer, my lord. Nobody has appeared. In the meantime, some developments is there, my lord. A CRP was filed that got dismissed. We filed the CRP that got dismissed, and there is an order in the CRP directing us to vacate the premises, my lord, in the meantime. So the execution proceeding is now going on, and actually it would have been, my lord, the second appeal as well as the CRP both should have been heard together. I don't know, my lord, I was not there at that point of time. Some other advocates are conducting the case. In any case,
who filed the RSA?
My lord, we are the plaintiff. We are the plaintiff. We have filed the RSA.
So you were the appellants in the RSA. And who filed the CRP?
We filed. Look, what has happened, my lord?
How both can be maintainable?
My lord, that is why, my lord, I have indicated, my lord. My lord, the plaintiff filed a suit against the defendant. Defendant is the landlord, he's a tenant. And the suit was dismissed. But in that suit, while filing the written statement, the defendant landlord has filed a counterclaim. That counterclaim was allowed, directing my eviction. And on the ground that I am defaulter and bona fide requirement in his favor. So what has happened, my lord? Against my dismissal of the suit, he has preferred a title appeal, and against allowing the counterclaim, he has filed another title appeal. So two judgments were passed in two title appeals. Against the first title appeal, both title appeals were dismissed. Against the first title appeal, second appeal has been preferred, and against the second title appeal where eviction has been confirmed, CRP has been filed. My lord, I was not the conducting counsel at that point of time. My lord, I have indicated because I have to indicate. Otherwise, if I say that since the appeal is pending, lordship may stay, my lord, that would not be fair on my part. That is why I have annexed everything in the record. If lordship kindly comes to the judgment in title appeal number 1, the first judgment is at page number 13, my lord.
Let us do one thing.
Yes.
This application be tagged with the CRP.
CRP order I have annexed here. Everything is there.
No, the record. Along
Yes,
with the record.
Yes, my lord. Lordship.
First, Mr. Dinner, learned counsel for the applicant. This application under Order 41, Rule 5 of the Code of Civil Procedure, dated section 151 of the CPC price, the applicant has priced for staying the impugned judgment and decree dated 29/11/2020. Passed in titles of number 112 struck 2015, and further proceeding of title execution case number 9 of 2024, along with the order passed on 3/7/2025 by the learned civil judge junior division number 1 Kamrup and Guwahati, entitled execution case number 9 of 2024 till disposal of the RSA number 1 on 9 of 2024. During the course of hearing, Mr. Nath has pointed out that another one CRP, being CRP number
59 of 2024, order is at page 73. Annex 5.
Being CRP number 59 of 2024 is also pending.
No, it
between
is
the same parties.
It is dismissed, Lord.
CRP is dismissed.
It is dismissed. It is already dismissed. The order, final order, my lord.
This is the dismissal order.
Yes, this is the dismissal order, my lord. It is the judgment and order. Starts at page number Annex 5, my lord, page number 73, and the final operative portion, lordship will find page number 77.
I was under the impression that it is also pending.
No, my lord, it is dismissed. In fact, at that stage only, the council should have mentioned, my lord, that both we take it together.
You delete the last part. Mr. Nath, learned counsel for the applicant submits that RSA has already been admitted by this court. And after framing of substantial question of law, a notice has already been issued to the respondent, and the record has also been called for. And as such, there is a requirement for staying the impugned judgment and decree passed by the learned first appellate court. First appellate court.
For the court below, the trial court.
No, this IA is for staying, or this is under section 5 of. Oh, okay.
Lordship.
For staying the operation of the impugned judgment and decree dated 29/11/2024, passed in title suit number 112 of 2015, and further proceeding of title execution case number 9 of 2024. Since the connected regular second appeal has already been admitted for hearing, and record has already been called for, and notice has already been issued to the respondent, this court is whether execution proceeding has been.
My lord, I have given all the orders of the execution court, my lord, at page number. It starts at page number 80, my lord.
And since execution proceeding has already been initiated before the learned executing court, being title execution case number 9 of 2024, there is a requirement for staying impugned judgment and decree, and also the title execution proceeding, and accordingly, this interlocutory application stands allowed. Operation of the judgment and decree dated 29/11/2022, passed in title suit number 112 struck 2015, and further proceeding of title execution case number 9 of 2024, along with the order dated 3/7/2025, passed by the learned civil judge junior division number 1 Kamrup M at Guwahati, in title execution case number 9 of 2024, stands stayed till disposal of the regular second appeal. In terms of this, IA stands closed.
But I must indicate one thing, my lord. Last page of the order, my lord, last page of my IA, the execution case was fixed on 21/7. The 3/7 order fixes the execution case on 21/7. Now in 21/7, they have filed an application for police help to evict me, and that patient has been court has
that order has already been stayed by this court.
My lord. I'll let you.
No, have you not mentioned that proceeding before this court? No, that application,
21.
in this application,
No, I filed it.
that order?
I filed it before that. 21, before 21/7, I filed this. That is why I could not mention.
So is it part of the record?
Page number 21, it was fixed on 3/7 order I have given. Kindly see the last page, below.
No,
Last
that order has to be stayed.
3/7 I have prayed because at that stage 3/7 was the order. But in the meantime, 21/7, another order has been passed. That I could not annex.
No, no, that is part of the record.
I kindly take my eye for more. No? I'm sorry.
So you have mentioned in the post title.
Yes, yes. 3/7 I have meant. I have.
Yes, I have already dictated to stay this order.
Lodge.
May I please your lordship? Lordship, this has been filed for condemnation of delay of 42 days, lordship. So notice may go, lordship.
Okay. Third is sir.
You Ghosh, lordship.
Learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act is preferred to the applicant for condemnation of delay of 42 days in preferring connected civil revision petition against the judgment, against the order dated 25/2/2025 passed by the learned additional district judge within bracket FTC dashboard at Summit 4 and Major case number 41 of 2023. Let notice be issued to the respondent returnable in forwards that be taken by registered post with AD and also the legal purpose within a account to the list of purposes.
Deeply obliged, lordship.
I'm sorry. I'm sorry. Like in the RSA, I may have to take free steps to the respondent.
Pardon?
In my RSA, I may have to take free steps to the respondent because the steps has not come, earlier steps.
Whether that RSA is listed today?
Yes, RSA is with that. With IA, RSA is there.
Cause list of put. It's the purpose. Because the hard means are not learned counsel for the FLN. It's not good. Official dated 19/7/2025 indicates that notice issued to the respondent return answer with a report. Accordingly, it is provided that learned counsel for the appellant shall obtain necessary instruction and take fresh step upon the respondent by registered post with AD and also visual process within a week from today.
Gotcha. Oh, no.